The Honourable, the Speaker.
Almighty God, we give thanks to you, the Creator of the universe, and humbly beseech you to direct and prosper the deliberations of the members of this house here assembled for the advancement of your glory and the trust and welfare of the people of Trinidad and Tobago. Grant that peace and happiness, truth and justice may be established among us for all generations. Amen. Amen. Namaste. Of a new member, announcement by the Speaker. Honourable members, Honourable Stuart Young MP, Member for Port of Spain North, St. Anne's East, Dr. Lakram Persad Bodo, MP, Member for Faisabad, and Dr. Bohindradat Tiwari, MP, Member for Caroni Central, have asked to be excused from today's sitting of the House. The leave which the members seek is granted. Honourable members, as you may be aware, our former colleague, Mr. Rennie Dumas, passed away on Sunday, 14th May 2017. Mr. Rennie Dumas served with distinction in both the House of Representatives and the Senate. He was first appointed as a senator on January 10th, 2001, and was then assigned as Minister of State in the office of the Prime Minister from December 28, 2001 to October 9, 2002. During the period 2002 to 2007, Mr. Dumas held the portfolios of Minister of Public Utilities and the Environment and Minister of Local Government. He was then elected to the House of Representatives as the member for Tobago East on November 5, 2007, where he served until May 2010 as the Minister of Labour and Small and Micro Enterprise Development. During his service, Mr. Dumas contributed to 46 bills, 10 motions, and served on 8 parliamentary committees. I now invite you to pay tribute to our departed colleague. Member for Tobago East.
Madam Speaker, I stand here today with a heavy heart to acknowledge the life of Rennie Stretch Dumas. In a personal capacity, I would have known him as my campaign manager. And what I admired most about Mr. Dumas was his intellect. He was quite educated, quite eloquent, but most, and for me, more important, he was a humble, loving giant of a man. Giant in stature, giant in terms of his personality, but Rennie the man was truly the people's man. Tobago East is a better place for having him represent us. Tobago is a better place for having him represent us. But most importantly, Madam Speaker, Trinidad and Tobago would have benefited from his intellect. And personally, I would have benefited from him being a compassionate, caring, and effective campaign manager. I stand here and join the rest of Trinidad and Tobago. I mourn his death, and I extend sincere condolences to his family, his friends, and his loved ones, and may his soul rest in eternal peace. Thank you.
Member for Oropuchis.
Thank you very much, Madam Speaker. Madam Speaker, it is indeed with a heavy heart that a few days ago we learnt of the untimely passing of a parliamentary colleague and friend to many of us on both sides of the House. I first became acquainted with Senator Rennie Dumas in the 6th Parliament, where we served on opposite sides, of course. And he had always distinguished himself as a very powerful voice, powerful speaker, and very passionate speaker. On behalf, like Coover South, he had a booming voice, and he distinguished himself by his compassion and his passion for the people of Tobago and for the various efforts that he led. I have one, if you may just permit me, I have one enduring memory of Senator Dumas. In the 6th Parliament, Madam Speaker, there was once a motion on sustainable development in the Parliament. And then myself, as a young senator, returning from abroad, fresh with a PhD, I stood in the Parliament to deliver, I think, a 60-minute address on sustainable development, quoting from every journal and every article imaginable. And I received some praise for the speech. Senator Dumas stood after me, representing the opposition PNM, and he said, I don't know what Senator Munilal said there. That was just wishy-washy. He made news every hour, on the hour, for 2 days. It was a political lesson of sort. But such was the nature of the man. He had a grassroots flair and a great character. He was fondly called Stretch, as we all know. And when he served later as Minister of Labour, an area where I also practiced in industrial law and labour and industrial relations, I also worked with him again. And he was also very helpful, very thoughtful, and supportive. Time and time again, when he would be passing through constituencies, particularly opposition constituencies and so on government business or on private business, he would make it his business to drop by the constituency office to say hello. If he sees the MP on the street, he would pull aside, come out to talk a few minutes and so on. He had that character which I think is so important for politicians as well, this ability to touch base with the grassroots and really carry about themselves with a dignity and fellowship, although we are on opposing sides and we will not always agree on policy and program. His death is untimely at a relatively young age. On behalf of the opposition and the United National Congress and the member for Siparia, who was also his colleague for many years, and the member for Caroni East, I'm sure as well, and Tabakit and others, Samuel Barataria as well. I want to extend condolences to his family, his friends, the community, which he represented, and to the government and the party, which I know he was very fond of and loved, his own political party. Senator Dumas, like all of us, had our strengths, also our weaknesses. He was not perfect. I don't think any of us are. But he has left us with enduring memories, and he was really a great soul. And I extend condolences on behalf of this side to his family and the people of Tobago and all those groups that he was involved with. Thank you very much.
Honorable members, having served in the House with Mr. Dumas, I too would like to pay tribute to him. Mr. Dumas has held several portfolios in the public service, and he will always be remembered for his selflessness and patriotism in serving our nation. We will forever be grateful for his contributions in this House and by extension, the wider community of Trinidad and Tobago. Today, we remember not only the man who died, but also the noble life of service and selflessness which he lived. In our hearts, we will always treasure the Honorable Mr. Rennie Dumas as a father, a brother, a friend, a colleague, a mentor, and a true servant of our nation. I take this opportunity to express my sincerest condolences to the Dumas family during this time of mourning, and I pray that the Almighty grants them comfort and consolation at this time of their bereavement. May his soul rest in peace. I now ask that we stand and observe a minute's silence. Members, I have directed the clerk of the House to send a letter of condolence to the family of the late Mr. Rennie Dumas on behalf of the members of the House of Representatives. Kindly have a seat.
Bills brought from the Senate, petitions, papers, reports from committees.
Member for Laventille West.
Very much, Madam Speaker. I have the honor to present the following reports. One, the first report of the Joint Select Committee on National Security for the second session 2016-17, 11th Parliament, on the follow-up inquiry into the status of the investigation of the Police Complaints Authority and the Trinidad and Tobago Police Service into the events surrounding the day of total policing on March the 23rd, 2015. And two, the second report of the Joint Select Committee on National Security for the second session, 2016-2017, 11th Parliament, on the inquiry into the practice whereby prisoners are granted access to services outside of the prison facilities. Thank you, Madam Speaker.
I call on the member for Diego Martin, North East.
Thank you very much, Madam Speaker. I have the honor to present the following report. The second interim report of the Joint Select Committee appointed to consider and report on the Gambling, Gaming and Betting Control Bill 2016.
For paper 3, I call upon the member for San Fernando West.
Madam Speaker, I have the honor to present the following report. The seventh report of the Public Accounts Committee for the second session, 11th Parliament, on the examination of the report of the Auditor General on the public accounts of the Republic of Trinidad and Tobago for the financial years 2014 and 2015, with specific reference to the Ministry of Education.
Prime Minister's questions, urgent questions.
Member for Princess Stop.
Thank you, Madam Speaker. Madam Speaker, question 1 to the Minister of Tourism. In light of the justifiable public interest surrounding a phone bill of $59,601.60 incurred by the Minister of Tourism during an official trip to the Bahamas, could the Minister indicate whether this bill has been paid to date?
Leader of the House.
Yes, it has.
Mr. Stam.
Madam Speaker, the question is related to the Minister of Tourism. Having the Minister and the member for La Joquita Talparo answer, I hope the Honourable Member could also advise this House whether the Minister of Tourism, I hope that the member for La Joquita Talparo who's answering could advise his Honourable House whether or not, in light of government's mantra of waste, mismanagement and corruption, whether the Minister of Tourism is prepared to pay $59,601.60 to the government of Trinidad and Tobago, going back into our nation's coffers.
Member, I'm not sure I know what the question is. Please, just the question.
Madam Speaker, thank you. The question is a very simple one. Is the Minister prepared to repay or reimburse the Ministry?
Madam Speaker, may I offer apologies? Sorry, may I be allowed? The Minister was outside. She's now here, so she will answer the questions.
Yes?
A question one to the Minister of Tourism. In light of the justifiable public interest surrounding a phone bill.
Member, the question was already answered. So
may I ask the supplementary
yes,
to the
you
Honourable
may.
Minister? Thank you, ma'am. Honourable Minister, can you indicate to this Honourable House whether you are prepared to repay this sum to the Ministry and to the Government of Trinidad and Tobago and the public purse with respect to this figure in light of your mantra of waste, mismanagement and corruption?
Member, for Princess Tong, I won't allow that as a supplemental question. It does not arise out of the response that was given. Member, I appreciate that we might all have a certain sense of anxiety when we come in here, okay? But even though I recognize that, I expect us to abide by the standing orders. I have ruled that the supplemental question does not arise out of the answer that was given. You're allowed another question. Member for Princess.
Thank you, Madam Speaker. Madam Speaker, in light of the SRC not making a provision for that sort of expenditure, could again the Honourable Minister indicate, based on that SRC provision, whether she's prepared to repay this sum in light of that SRC report not making that provision for a government minister?
Minister of Tourism.
Thank you, Madam Speaker. Madam Speaker, as was stated earlier by the press release that was given by the Ministry of Tourism, the matter is still under investigation, and I want to place on public record, Madam Speaker. I'm answering the question.
Yes. Member for Princess Tong. I can't be stretched beyond the limits. Member for Cover South. I would like us all to comply very early in today's sitting with the standing orders with respect to members who are not speaking. Minister of Tourism.
Yes, Madam Speaker, when I traveled to the Bahamas to be a part of the Caribbean Tourism Organization meeting of ministers, I traveled for work. I didn't travel to play. When I was there, Madam Speaker, I was required to be in contact with the ministry at home and to work as a part of the working group that was preparing to present to the Council of Prime Ministers for CARICOM the following month of February. So we would have exchanged documents over email, downloaded documents to deal with the work of our working group. So, Madam Speaker, the breakdown of the bill has been also released, and it was $1,111 for talk for the entire month. We would have seen in the breakdown of the report that we would have had so far, the $50,000 would have been from data roaming. And as I said before, I would have asked TSTT to go to do a further investigation into the matter, and we are waiting that.
Member for Princess Tong, I would invite you to just take a little walk and therefore get all your anxiety under control, and you could be allowed back in. Member for Cover South.
Thank you, Madam Speaker. Is the Minister willing to lay in this House the paper trail which initiated the investigation in relation to this said phone bill?
I won't allow that as a supplemental question. Member for Naparima.
Would the minister be kind enough to lay in this house the information, the final information of the investigation with TSTT concerning this bill?
Minister for Tourism.
Madam Speaker, when we receive the relevant document and information from TSTT, what is required to be laid in this house would be laid in this house.
Member for Couva North.
Thank you, Madam Speaker. To the Minister of Tourism, with respect to a telephone bill amounted to some $59,000, which was incurred by the Minister during an official 4-day overseas trip, would the Minister advise this House as to whether any time frame was given by TSTT for a conclusive report on the query as requested by the Minister into the matter?
Minister of Tourism.
No.
Member for Couva North.
Thank you. How does the Minister intend to cut and contrive at her ministry in light of her racking up a $59,000 bill over 4 days?
Question. Member for Couva North.
Thank you, Madam Speaker. Will the Minister be paying the extra charges on her phone bill as the limit for a cabinet minister is $25,000?
I will not allow that as a supplemental question. Member for Couva South.
Thank you, Madam Speaker. In relation to this particular bill, could the minister advise if Wi-Fi services was available at the hotel and the conference center?
Minister of Tourism.
Madam Speaker, as the release that was issued by me from the Ministry of Tourism, I would have stated in the report whenever Wi-Fi was available, I utilized Wi-Fi, and whenever it was not, I accessed the internet otherwise. Thank you.
Question number 3.
Thank you, Madam Speaker. To the Minister of Works and Transport. Can the Minister state the rationale given by the Port Authority of Trinidad and Tobago for shortlisting the MV La Caracola to service the sea bridge between Trinidad and Tobago, and how many proposals were submitted?
Minister of Works and Transport.
Thank you, Madam Speaker. Madam Speaker, there were 7 unsolicited bids which were contained in a database at the Port Authority of Trinidad and Tobago. And based solely on the specifications submitted, 2 vessels were shortlisted, one of which was the MV La Caracola. In keeping with the Port Authority methodology on finalizing offers to any prospective tenderer unless due diligence is performed. This includes, but is not limited to, surveys, inspections, sea trials, and of course negotiations on terms and conditions of the prospective charter. The identification of a selected vessel is but one step in the entire process. Thank you.
Member for Point of Peer.
Speaker, to the Minister, supplemental. Could the Minister state the location and the owners of MV La Caracola?
Minister of Works and Transport.
Madam Speaker, as the Minister of Works and Transport, the owners of the vessel, based on the recommendation to the port, has not been identified to us at this point in time because there are still ongoing negotiations and due diligence being carried out on the vessel. Thank you.
Member for Point of Peer.
And the second part of that supplemental was the location of that vessel presently.
Minister of Works and Transport.
As correspondence from the Port Authority to the Ministry of Works and Transport, this vessel is located in Venezuela. Thank you.
Member for Couva North.
Thank you, Madam Speaker. Could the Minister inform this House of the precise time frame for the acquisition of a 3rd cargo vessel to ease the sea bridge woes between Trinidad and Tobago?
Minister of Works and Transport.
Thank you, Madam Speaker. Madam Speaker, a recommendation has been made by the Port Authority. The process has started to give the opportunity to have a 3rd vessel in the shortest possible time to ensure that when the vessels goes on dry dock, we will have a smooth transition of the transport between Trinidad and Tobago.
Member for Oropouchis.
Thank you very much. In this context, Minister, could you indicate whether or not legal action has been initiated against the owners of the Galicia as you promised some time ago.
I will not allow that as a supplemental question. Member for Couva North.
Thank you, Madam Speaker. Minister, can you say what type of cargo vessel has been discussed to date by Port Authority?
Minister of Works and Transport.
Thank you, Madam Speaker. A cargo vessel is a vessel used to transport cargo. So based on the...
I'll rephrase the question.
Based on the specs...
I'll rephrase the question.
Oh my. This is a problem.
Member for Couva North.
Madam Speaker, I'll rephrase the question. Mr. Minister, is it a barge or is it a different type of cargo vessel?
Minister of Works and Transport.
Madam Speaker, right now on the air bridge we do have a barge and a cargo vessel. Sorry, the sea bridge. Sorry about that, Madam Speaker. And the vessel that is being sought is a vessel that will take the required cargo to Tobago in the shortest possible time. Thank you.
Member for Mayaro.
Very much, Madam Speaker. Question number 5 to the Minister of National Security. After the assurances given by the Honourable Minister at the sitting of this House of Representatives on Friday, 28th of April, with reference to the provision of a fire tender at the Mayaro Fire Station, is the Minister aware that after one call-out the tender had gone missing?
Minister of National Security.
Thank you, Madam Speaker. Madam Speaker, the fire tender assigned to the Mayaro Fire Station is not missing as such. The fire station is the fire tender is under repairs. But let me put on the table also, Madam Speaker, that the last government, in fact, was the one who opened the Mayaro Fire Station. Now, when you are building a fire station, you are supposed to order fire equipment almost before you build the fire station, because the lead time for fire equipment to come into Trinidad and Tobago is about 12 to 18 months. What is happening now, we are forced to move fire tenders from other stations to Mayaro. The fire chief right now has indicated to me that he is in fact sending a new fire tender to the Mayaro Fire Station. But I want to also again repeat that the lead time for fire equipment to come into Trinidad and Tobago is 12 to 18 months. The last government did not order fire equipment in time with the Mayaro Fire Station. Madam Speaker.
Thank you very much, Madam Speaker. The fact that it takes 20 months, Minister, 18 to 20 months, can you have the Chief Fire Officer given any assurances as to when we can expect a tender in Mayaro based on that?
Minister of National Security.
Thank you, Madam Speaker. The Chief Fire Officer has indicated that fire tenders should be in Mayaro over the weekend, Madam Speaker.
Member for Mayaro, question number 6.
Thank you, Madam Speaker. Question number 6 to the Minister of Agriculture, Land and Fisheries. Can the Minister advise what urgent steps are being taken to manage the locust invasion currently affecting areas of the Mayaro constituency?
Minister of Agriculture, Land and Fisheries.
Madam Speaker, I thank the member for his question. There was no need in this case to take urgent steps. The ministry had been proactive in preparation for this seasonal activity. We've had locust problems in 2014, 2016, and during the nesting period, September to December last year, we recognized that we'd have an issue coming into this part of the year. And in relation to Mayaro, on Tuesday we noticed that the locusts had migrated from other areas into Mayaro in the Tableland area, which is on the edge of the Mayaro constituency, Riverside Road Pool, and other areas, and the ministry had already been prepared. We've put in place our measures of spraying on the low level with mist blowers, on the high level with the boom cannon sprayers. We're working with the regional corporation, and the farmers in the area have already seen a reduction in the swarms. But it is something that you are reactive about. There's very little you could do to control it in terms of having the presence of it, and it's just control measures at this time.
Member for Oropuch West.
Thank you, Madam Speaker. To the Minister of Public Utilities.
Question 7. In light of the fiery protest action recently conducted by the residents of Mova, can the Minister indicate what action has been taken to rectify the situation?
Minister of Public Utilities.
Thank you very much, Madam Speaker. This question is very vague and hard, difficult to comprehend. But for the sake...
Minister of Public Utilities.
Thank you, Madam Speaker. But for the sake of this honorable House and the Mova community, as I interpret it and as I understand it, the protest action recently experienced in the Mova area concerned a number of things: the condition of the roadways, the lack of employment opportunities according to them in the area, and the lack of water supply. The water issue was raised by residents of Angelina Terrace, which normally receive water from the localized intake, where the flow has diminished significantly on account of the dry season. The area referred to as Angelina Terrace, where residents are connected to the pipeline network, receives a supply on Wednesdays from 6 a.m. to Thursdays at 6 a.m. and on Saturdays 6 a.m. to Sundays 6 a.m. from the Mova Reservoir. That schedule is ongoing and will be faithfully continued. There is also a truck-borne supply based on requests, and we have 2 trucks in the area treating with those requests. We wish to underscore, the authority, WASA wishes to underscore, that there is no water supply shortage to the general Mova community. Customers who are connected to the pipeline have been receiving the scheduled pipe-borne supply as I have earlier described. And in order to supply the existing customers and to provide to residences not currently connected, the authority is immediately developing plans for installation of a new pipeline. Thank you.
Speaking time is expired, and members, the time for urgent questions has now expired.
Questions on notice, questions for oral response.
Leader of the House.
Thank you very kindly, Madam Speaker. Madam Speaker, we will be answering all questions for oral response, and there are no questions for written response.
Thank you. Member for Oropuch East.
Thank you very much, Madam Speaker. Question number 107 to the Honorable Prime Minister.
Prime Minister.
Thank you, Madam Speaker. On behalf of the Office of the Prime Minister, I have been advised by the OPM that the list of audit reviews completed to date is as follows. Caribbean Airlines Limited, a review of the monthly domestic airbridge subsidy, which is a requirement of government. Secondly, Community Improvement Services Limited, a review into revenue and receivables, project management, tendering, contract administration. Thirdly, Education Facilities Company Limited, a review of accounts payable, human resources, a diagnostic into the finance function, an internal audit risk assessment, and a diagnostic into the procurement function. With respect to National Entrepreneurship Development Company Limited, an operational review. With respect to National Flour Mills Limited, the financial year-end 2015 audit, a human resource audit. With respect to Taurus Services Limited, an end-of-year audit 2015. With respect to Trinidad and Tobago National Petroleum Marketing Company Limited, audit of the financial year end 2015 and 2016. With respect to the Trinidad and Tobago Postal Corporation, professional services regarding the 2008 year audit, professional services regarding the 2009 year audit, professional services regarding the year 2010 audit, and a year-end stock count for 2015 and 2016. With respect to the Water and Sewage Authority, an audit of financial statements of WASA Daily Rated Employee Pension Fund Plan for the year ended September 30th, 2015. With respect to the National Insurance Board of Trinidad and Tobago, an audit review of the years of 2015 and 2016. With respect to National Lotteries, a due diligence audit for an international firm in the gaming industry. With respect to the Trinidad and Tobago Electricity Commission, the annual audit for the financial year 2016. The list of audit reviews that are in the process of being completed, ongoing audits for Caribbean Airlines, for National Flour Mills, financial year end 2016 audit, and audit of divestment of rice milling operations. With respect to National Helicopter Services Limited, an audit of 2015 and 2016 financial statements. With respect to Trinidad and Tobago Postal Corporation, an audit services for the year ended September 2011. With respect to the Water and Sewage Authority, 2 IT audits into Oracle, EBS, a post-implementation review, and an audit of financial statements of WASA's Daily Rated Employee Pension Fund Plan for the year ended, September 30th, 2015. With respect to the National Insurance Board, audit review for 2017. Answer to Part C. The cost per audit, or the cost of audits, 1, for Caribbean Airlines, $474,468.75. For Community Improvement Services Limited, $336,055.28. For Education Facilities Company Limited, $1,786,878.10. For the National Entrepreneurship Development Company Limited, $393,936.45. The National Flour Mills Limited, $2,110,421. $2 million, yes. National Helicopter Services Limited, $299,200. Taurus Services Limited, $179,718.75. Trinidad and Tobago National Petroleum Marketing Company Limited, $1,559,110.63. Trinidad and Tobago Postal Corporation, $863,521. Water and Sewage Authority, $465,125.63. National Insurance Board of Trinidad and Tobago, $2,150,000. National Lotteries Control Board, $414,414. And the Trinidad and Tobago Electricity Commission, $500,000. The outstanding quantum of monies yet to be paid to the audit firm, $2,473,721.13.
Member for Oropuchis.
Thank you very much to the Honorable Acting Prime Minister. In response to this figure of $10.5 million in audit, could you shed light on the fact that both PricewaterhouseCoopers and Ernst & Young are doing audits on Caribbean Airlines at the same time?
Prime Minister.
Madam Speaker, I cannot verify the arithmetic of the Honourable Member, and with respect to audits being done by 2 separate firms, I will have to check that and report back.
Member for Naparimo.
Thank you, Madam Speaker. Question number 114 to the Minister of Education.
Minister of Education.
Madam Speaker, barring unforeseen circumstances, each government and government-assisted school is scheduled to receive in the second half of fiscal 2017 between 35 to 50 laptop computers, depending on the number of students entering the respective secondary schools at the Form 1 level. Thank you.
Member for Chaguanas East.
Thank you, Madam Speaker. Will the Minister give us some data with respect to the number of persons and the average per population of school? You said you did give a figure of computers. Will the Minister be able to tell us what is that percentage? How many persons to a computer on an average secondary school?
Minister of Education.
Madam Speaker, it all depends on the size of the secondary school and the intake of the secondary school. Some secondary schools have an intake of 2 forms, some have an intake of 3 or 4 forms. The average size of a form is between 25 and 30 students.
Is the Minister satisfied that the ratio of laptops to students is consistent with best practices in education globally?
Minister of Education.
The simple answer to that question is yes.
Member for Chaguanas East.
Thank you, Madam Speaker. Can the Minister state whether there are sufficient resources for teachers to deliver the curriculum via ICT?
Minister of Education.
Madam Speaker, that was one of the deficiencies in the last exercise, and we have done quite a large amount of work to ensure that our teachers are adequately trained. Thank you.
Fernando.
My understanding, Madam, is the Minister aware that in the state of New York, the ratio of computers to secondary school students 1-to-1. Would he, in the light of that, be prepared to retract his previous answer to my question?
I will allow that as a supplementary question. Member for Caroni East.
Is the Minister aware that over 6,000 laptops were distributed to principals and teachers during the 5 years of the People's Partnership Administration?
Minister of Education.
Madam Speaker, yes, I'm aware that a large number of laptops were distributed to teachers and students. It is our information that more than 90% of those laptops have crashed. Thank you.
Member for Couva South. Member for Couva South.
Thank you, Madam Speaker. Question 115 to the Minister of Public Utilities.
Minister of Public Utilities.
Madam Speaker, the Trinidad and Tobago Electricity Commission owes arrears to workers belonging to the following 3 bargaining units: the Oilfield Workers Trade Union, the Senior Staff Association, and the Estate Police Association. As it pertains to the OWTU, it is to be noted that negotiations for the period 2012 to 2014 were settled on November the 4th, 2016. The agreed settlement was based on a 10% increase to the workers for these years as follows: 2012, 3%, 2013, 3%, and 2014, 4%. Based on these negotiations, the Commission has agreed to make payment to the OWTU workers in the amount of $541 million. This payment has been broken down into 3 tranches. Tranche 1, which represents 29% of the outstanding arrears, valued at $153.39 million, was paid to workers in December 2016. Tranche 2 represents 36% of arrears and is valued at $200.815 million. The Commission has communicated with the OWTU and proposes to make this payment in 2 equal parts. As such, the first part, 100.408 million, is to be paid in June 2017, and the second part, which is valued at 100.407 million, is scheduled to be paid in September 2007. The final payment, tranche 3, represents 35% of arrears and is valued at 186.902 million. The Commission anticipates that this payment will be made to the workers in December 2017, subject to TNTEC's cash flow position, which I might add is troubling. Should any difficulties arise in making these payments, Madam Speaker, the Commission will not hesitate to promptly communicate with the OWTU. Madam Speaker, as it pertains to the Senior Staff Association and the Estate Police Association, negotiations are ongoing with these respective bargaining units. As such, arrears to these workers have not yet been settled or determined. I thank you.
Member for Couva South.
Thank you, Madam Speaker. Question 116 to the Minister of Tourism.
Minister of Tourism.
Madam Speaker, an audit of the human resources process at the TDC conducted by the company based on a request by the Board of Directors in 2016 when it was discovered that the staff complement increased from the approved organizational structure of 56 in 2005 to over 100 persons by 2016. The report on the audit of the human resource process was approved by the then acting CEO on October 12, 2016. At the time of the conduct of the audit, the company was using a 2011 organizational chart which was not approved by Cabinet that allowed for the employment of 154 persons. Conclusions drawn from the report include the following. Only the 2005 organizational chart was approved by Cabinet. The 2005 organizational chart facilitated the employment of only 56 persons. The review recommended, among other things, a comprehensive review of the organization, its chart, structure, and each department in an effort to determine the relevance and efficacy to the vision, mandate, and operations of the TDC. A new organizational chart be developed and properly approved by the Board of Directors, Line Minister, and Cabinet. A review of each position to determine its relevance to the TDC. A review of the qualification, resume, contract of each employee to determine if they are the right fit for the organization. A review of the resume, qualification, contract of each employee to determine if they are employed in the right positions currently and whether these employees should remain in the position should the organization chart be approved. Part B. With respect to Part B, Madam Speaker, the Tourism Consultants International Incorporated conducted a review on the company, and the said review was completed by June 15, 2016.
Member for Couva South.
Thank you, Madam Speaker. Could the Minister clarify the current status of the Tourism Development Company, please?
Minister for Tourism.
Madam Speaker, I'm sure the member is well aware that the government took the decision to, after the review was done, to close the company and to establish another tourism entity, one for Trinidad. The THA would establish one in Tobago, a regulatory authority also. Madam Speaker, thank you.
Member for Couva South.
Could the Minister advise if due consideration has been given by the proposal sent to the Ministry by the Communication Workers Union as it relates to restructuring the Tourism Development Company?
I will not allow that as a supplemental question.
Another question.
Member for Couva South.
Madam Speaker, question 117 to the Minister of Education.
Minister of Education.
Thank you very much, Madam Speaker. Classes in aviation-related courses at the certificate and the bachelor's level are being conducted at present at UGT's Point Lisas campus. Barring unforeseen circumstances, the students are scheduled to be relocated to the aviation campus in the second term of the academic year 2018. Thank you.
Member for Shagona, please.
Thank you, Madam Speaker. Will the Minister indicate to us where are the practicals for these programs being conducted?
Madam Speaker, I'm happy to respond to that question, to state that the practicals are at present being conducted at the Caribbean Airlines Limited and the National Helicopter Services Limited in Cuba. Thank you.
Member for Oropuch East.
Thank you very much. Madam Speaker, question number 118 to the Honorable Prime Minister.
Prime Minister.
Thank you, Madam Speaker. On behalf of the Prime Minister, I am advised that the following persons accompanied the Prime Minister on his recent trip to Houston, Texas. Firstly, the Honorable Minister in the Ministry of the Attorney General and Legal Affairs and in the Office of the Prime Minister. Secondly, the International Affairs and Protocol Officer, Office of the Prime Minister, a public servant. Thirdly, a Press Secretary, Office of the Prime Minister, a technocrat. Fourthly, a Web Specialist, Office of the Prime Minister, a technocrat.
Mr. Acting Prime Minister, are you telling us that the only persons who attended this key energy conference and key energy meeting are officers of the OPM for web press information and no technical officer from the Ministry of Energy, Permanent Secretary, Director of Minerals, no legal person from the Ministry of Energy for negotiations of any kind? Then what type of arrangements have been made there?
But which is the question?
Well, the first part.
Okay. Prime Minister.
He'll have to, Madam Speaker, he was carrying on at such a rate, I didn't catch everything. Could you kindly repeat it?
Yes, no, I must. Mr. Acting Prime Minister, are you telling us that the only personnel that accompanied the Prime Minister to a meeting or a series of meetings in Houston to discuss gas negotiations, the energy sector, investment projects for Trinidad and Tobago, are the information officer, the press secretary, and a web official from the Office of the Prime Minister, and not one technical officer from the Ministry of Energy and Energy Affairs?
Prime Minister.
Madam Speaker, the question asked for the persons who accompanied the Prime Minister on his trip, and the answer is as given.
Member for Oropuch East.
Did I ask the Acting Prime Minister, did any legal technical expert from the Ministry of Energy participate in those meetings in Houston?
Madam Speaker, as far as I'm aware, there were other persons at those meetings, but I do not have the precise details. They may have made their own travel arrangements. They may have been based in the United States. I would not want to venture that information without getting a proper check done of the record.
Very much. Could the Honorable Acting Prime Minister tell us then on what basis were arrangements deemed to be negotiated and settled in the gas sector at a meeting that had no technical expertise from the Ministry of Energy?
Prime Minister.
Thank you, Madam Speaker. I think it is precipitous and premature and simply wrong of the member for Oropuch East to make those assumptions. I will check into this matter and respond in due course.
Final question.
Member for Oropuch East.
Then the final question to the Honorable Acting Prime Minister. Honorable Acting Prime Minister, in the interest of continuity of policy, program, and projects, are you suggesting that when another government comes into power very soon, we will have to speak to the web officer to understand what happened in Houston and what policies should be continued.
Okay, so I would not allow that as a supplemental question. Member for Oropouche East. Are you foregoing the question number 119?
19? Yes, ma'am. The Minister of Works and Transport, 119. Thank you.
Minister of Works and Transport.
Thank you, Madam Speaker. Madam Speaker, it is the view of the Port Authority of Trinidad and Tobago and the Ministry of Works and Transport that a contract existed with the agent of the MP Superfast Galicia for the period May 1st, 2016 to October 31st, 2017. In the circumstance, the issue of the alleged non-approval by Cabinet for the recommendations of the Board for an extension of the contract does not arise. Thank you.
Member for Oropouche East.
Minister saying that no recommendation was taken to Cabinet from the Board for an extension of the contract.
Minister of Works and Transport.
Thank you, Madam Speaker. Madam Speaker, based on information submitted to me, the line minister, no note was taken to Cabinet for the extension of the project.
Member for Oropouche East.
With regard to your answer to the question, substantive question, are you prepared to tell us whether your ministry has initiated legal action against the agent and or owners of the Galicia for a breach of contract?
Minister of Works and Transport.
Thank you, Madam Speaker. Madam Speaker, a pre-action protocol letter have been sent to the charter of the MP Superfast Galicia.
Request for leave to move the adjournment of the House on definite matters of urgent public importance.
Member for Rennie East.
Thank you, Madam Speaker. In accordance with Standing Order 17 of the House of Representatives, I hereby seek your leave to move the adjournment of the House of Representatives for the purpose of discussing a definite matter of urgent public importance, namely the fact that presently the health and the lives of thousands of patients are seriously endangered through the dispensation of inefficacious drugs through the Chronic Disease Assistance Program, CDAP. The matter is definite because it refers to the admission by the Honourable Minister of Health in Parliament on May 11, 2017, that CDAP drugs for the treatment of diabetes and hypertension are not effective based on empirical data from the Pan American Health Organization finding. The matter is urgent because these ineffective CDAP medications for diabetes and hypertension and others continue to worsen their diseases, patients' diseases, and to imperil the lives of thousands of patients suffering from chronic ailments, and that no new procured pharmaceuticals have been implemented for the drugs presently used. The matter is of public importance because of the very disturbing impact on a significant part of the national population who depend on and manage their diseases from medications of the Ministry of Health administered CDAP.
Honourable members, I am not satisfied that this matter qualifies under this standing order. I advise that the member pursues this matter under Standing Order 16.
Statements by ministers, personal explanations, introduction of bills, motions relating to the business or sittings of the House and moved by a minister.
Leader of the House.
Thank you very much, Madam Speaker. Madam Speaker, having regard to the second interim report of the Joint Select Committee appointed to consider and report on the Gambling, Gaming and Betting Control Bill 2016, I beg to move that the committee be allowed an extension of 6 weeks in order to complete its work and submit a final report by June 30th, 2017.
Honorable members, the question is, be it resolved that the Joint Select Committee appointed to consider and report on the Gambling, Gaming and Betting Control Bill 2016 be allowed an extension of 6 weeks in order to complete its work and submit a final report by June 30th, 2017. All in favor say aye.
Aye.
Any against? I think the ayes have it.
Public business, government business, bills, second reading.
The Attorney General.
Thank you, Madam Speaker. Madam Speaker, I beg to move that a bill entitled An Act to Amend the Bail Act, Chapter 460, be now read a second time. Madam Speaker, I am very pleased to commence debate of this particular bill in the context of the package of laws which we've brought to the Parliament, all squarely centered upon improvements to the criminal justice system and definitely the improvement to the lives of the people of Trinidad and Tobago. I'll repeat again that the concentration upon the national mischief is removing the obstructive time frame from the equation. The closure of the gap between the reporting of a crime and conviction and sentencing by a court in this jurisdiction is approximately close to unacceptable. The statistics show us that there are cases in the system well beyond 20 years in backlog. We have, through successive debates in this particular session, focused upon the thousands of backlog matters both at the magistracy and also at the High Court and Court of Appeal. It's interesting to note that the amendments that we propose today, centered upon the Bail Act itself, focus upon dealing with an improved access to bail, which has a direct correlation to the prisoner population of this country and a direct nexus to the Constitution of the Republic of Trinidad and Tobago. After all, it is squarely the constitutional rights that are in balance today. On the one hand, we have Section 4A of the Constitution, which of course guarantees us the right to liberty, to freedom, to protection, life, liberty, security of the person, enjoyment of property, and the right not to be deprived thereof except by due process of the law. We also have on deck in this bill the Section 5 rights, particularly at Section 5(2)(f) of the Constitution, where the exceptions provided in law to the fundamental rights state that no law should derogate from rights, and in particular the qualification given that derogation must comply with certain constitutional standards in Section 13. The derogation given and the caution given at Section 5(2)(f) is that without prejudice to subsection 5(1), but subject to the Constitution and Sections 54 in particular, Parliament may not deprive a person charged with a criminal offence of the right, Roman 1, to be presumed innocent until proven guilty according to law, but this shall not invalidate a law by reason only that the law imposes on such person the burden of proving particular facts. 2, there should not be a deprivation of the right to fair and public hearing by an independent and impartial tribunal. And 3, importantly, that someone before a court for a criminal offence should not have a deprivation of the right to reasonable bail without just cause. Now, in Trinidad and Tobago, Madam Speaker, the manner in which the law manages these countervailing rights was reformulated in principle in 1994. 1994, Attorney General Keith Sobian, standing in the Parliament then, moved the consolidation and restatement of the laws in relation to the manner in which a court considers the access to bail within the constitutional parameters. And born in that bill coming to life in Act number 18 of 1994, which became operational on the 15th of September 1994, was the mechanism in law prescribed for someone who is brought before the court to access the position of bail. Specifically, this concept of access to bail is something which must be carefully balanced. On the one hand, there is, of course, the overriding separation of powers principle, which says that the judiciary ought to have the liberty and freedom to conduct the affairs of state as it should. On the other hand, we have Section 2 of the Constitution, which prescribes the supreme law, and then we have laws in statutes, as we have the Bail Act, Chapter 460 before us. And in dealing with that prescription to bail, we have to be very careful that we preserve the balance of laws between the judiciary's discretion, which ought not to be fettered or fettered only in certain circumstances provided by law, and also these rights as to how we're going to consider what the Parliament directs by way of primary law to be unacceptable exceptions to the rule that bail should be granted to all. Specifically, the Act was amended approximately 12 times. In the period 2005 to 2015 in particular, we saw successive parliaments, successive governments come to the fore and say that the bail provisions needed to be treated with. And we introduced the right to appeal. We introduced the provisions where bail was not going to be granted in the context of kidnapping for ransom, in the context of use or possession of firearms, in the context of the anti-gang law which came about, in the context of sexual offenses against children, and in the context of trafficking in persons. And I'm generalizing, of course, across the 12 amendments which were brought to successive parliaments. Last year, on the 1st of July 2016, the Parliament was moved again to consider Amendment number 13. And that would have been to allow for the saving of law which was set to expire pursuant to successive sunset clauses. In particular, the Parliament was moved then to continue the anti-gang law and the amendments to the Bail Act, which allowed for pre-trial detention if evidence was taken beyond 120 days, that you would be allowed to proceed onto your application for bail, but that if you had commenced your taking of evidence, that you would be prohibited from accessing the court to be allowed the consideration for bail. So Parliament had stepped in, successive governments, one on top of the other, to consider the prohibition of the granting of bail. As we all know, the attempt to keep that law alive, to keep the successive amendments coming from 1994 straight up to 2015 alive, that unfortunately collapsed as there was not 3/5 support in the House of Representatives. It's interesting to note, Madam Speaker, that the flip side of the coin is the consideration not of how you continue to keep people incarcerated, but now the position is making sense of those who are incarcerated. And I'm very pleased to say that the government actually started as one of its primary exercises a consideration of the prisons system. In 2016, we went to the public forum with facts and statistics to speak to Trinidad and Tobago about what Trinidad and Tobago was managing. We looked at the position of the remanded population and the convicted population, and we rolled out for the first time as a government, at least from my recollection and research, we rolled out for the first time what our system of incarceration looked like. And we saw in particular that back then in 2016, the remand population was close to 2,200 persons in total. 2,200. I'll give you the current statistics in just a moment, Siparia. So we noted back in 2016 that and forgive me, it was April 6th of 2016, we looked at the actual position. We first of all did the tour of facilities. We confirmed to the population that there were 8 points of incarceration centers, 8 prisons. There was 1 industrial institution. We noted the Port of Spain prison built in 1812, the Carrera convict prison in 1877, the Tobago convict prison built in 1902, Golden Grove prison built in 1940. We looked at the remand prison built in 1950, the women's prison in 1970, maximum security built in 1998, Eastern Correctional Rehabilitation Center built in 2010, and then we looked at the Youth Training Center as constructed in 1949. When we looked at the figures then, we saw in terms of capacity at these prisons that at YTC we had a capacity, actual occupation of 40% of capacity. At Golden Grove Prison, the capacity filled was 67%. At the women's prison, the capacity filled was 32%. At the remand prison, the capacity was 157%, meaning that it was 57% over-occupied with 1,032 people where a capacity was really 655.
Would the member who is offending the rule with that device please leave the chamber? And all other members are advised to put their handheld devices. I'm still hearing the device. I am still hearing the device. Can we have some order, please? I'm on my legs. All other members are advised to take off their devices or put them on silent.
Thank you, Madam Speaker. Madam Speaker, the maximum security prison was at 39% capacity. The Port of Spain prison at 290% capacity. Carrera convict prison at 108% capacity. The Eastern Correctional Rehabilitation Center at 32% capacity. The Tobago convict prison at 170% capacity. Now, looking at those capacities and knowing that my learned colleague, the Minister of National Security, will speak in greater detail to those, we took a tour next of what persons were in there for. Now, it's important to note for those listening through you, Madam Speaker, that you can be incarcerated for 2 purposes. One, you have been convicted under the laws of Trinidad and Tobago and are serving sentence as a convict. Or secondly, that you're awaiting your trial and you are therefore remanded or in pre-trial detention. When we looked at the category of offenses for pre-trial detention, 42% of our capacity was being used for murder. Approximately 1,000 persons incarcerated for murder, and murder is of course a non-bailable offense, so you can't access bail. Illegal drugs, 5% of it was simple possession, trafficking 6%, sexual offenses 7%, possession of firearms and ammunition 13%, and there was a category called other, which was 27%. In that category of other, there were people who were spending time on remand for using obscene language. One person there, 5 years and 6 months in remand. Failure to pay maintenance, 6 months in remand. Breach of a traffic regulation, 1 year on remand. Malicious damage, 2 years and 3 months on remand. When we looked further and we examined what the judiciary was doing in terms of the pull of persons out of the prison population into the judicial system, by now this House is quite familiar with the statistical caseloads. On average, at the Magistrates Court, we know there are roughly anywhere between 120,000 to 142,000 cases in the magistracy per year. There's a vast volume of them comprising traffic matters. When we look to the positions of case flow through the judiciary, we see that the High Court has significant backlog there with some 29,000 odd indictable cases coming up. We look to the Court of Appeal, we see that there are significant issues there. And when we look to the time for and averages for disposition by way of referencing how fast persons come out of the incarceration for pre-trial detention, we see that the 6-year average for criminal cases disposed in the law term between 2009-10, that's 1 year, straight up to 2014-2015, on average there were 173 non-capital indictments filed and 83 of them were disposed. That's a 47% disposition rate. In the translation of that to the number of people who were before the court, that 173 non-capital matters equals to 1,300 people. Of those cases disposed, when you translate the number of cases to people, of the 1,300 people involved, only 84 of them, or 6% of them, actually have had disposition of their cases as a 6-year average coming from the judiciary. When we look to the magisterial, indictable summary and indictable cases heard summarily, the 6-year average is 23,803 cases. When we look to the new criminal indictments that's filed in the High Court, we're looking at an average of 219 indictments per year. Now I want to put this against the fact of the resources that manage this. Firstly, when we looked at the judiciary, we're looking at the Court of Appeal prior to the proclamation of the Children and Family Division amendments and the 5th schedule there. We have 10 Court of Appeal judges, 29 High Court judges, 57 magistrates, and clerks of the peace, 12. When we look to the magistracy, we see that there are a cross of resources involved there. In particular, we're looking to the fact of the Trinidad and Tobago Police Service having only 53 prosecutors, they handling 95% of the prosecutions. Of those 53 prosecutors, only 8 of them are attorneys at law, the rest are police prosecutors. When we look to the DPP, we note that they are now up to 81 members of a staff complement of 130, they having had 32 persons or posts filled recently. But when we look against this position of the limited resources in the judiciary, the limited resources of prosecution, the remand statistics looking as they do with persons on remand for up to 17 years, when we look to a 6% of persons affected in terms of cases disposed of, and we compare that across what the country spends, it's actually quite an interesting figure. From a whole of government ministerial perspective, the Trinidad and Tobago Police Service over the last 6 years alone has spent $15.1 billion. When we look to the 5 years prior to this present government, the total figure spent was approximately $26 billion. Office of the Prime Minister, Ministry of National Security, the AG's office, the Ministry of Justice and Communications, which does the publication and products of that, $26 billion plus $15.1 billion. Now, Madam Speaker, those statistics are put in the context of the access to bail. Sure.
Statistics that you have on the amount of cases in the appeal court, whether there are any masters, and the amount of cases due to traffic offences.
Sure. I can immediately inform that there are approximately 100,000 cases in traffic offences. 100,000 cases, which is why we are debating the Motor Vehicle and Road Traffic Act to decriminalize those matters, to remove 100,000 cases away from judicial attention and deal with them by violations. I'll get you the figures for the masters and the Court of Appeal positions. I can do that during the course of the debate, and certainly in wrap-up I don't have them with me immediately. But, Madam Speaker, when we look at the further figures now, it's important to drill down to the fact of the incarcerated population. We're talking about access to bail. We know of the 3,000 odd persons, 3,200 odd persons who are there, 1,000 of them are there for murder, this is on average, can't access bail. But of the current position as at March 9th, 2017, we have 2,280 people in remand, pre-trial detention. Of that 2,280, we have 1,170 of them there for bailable offences. Of the 1,170, 839 are still incarcerated, even though they have been granted bail. So they've gone to court, they've made an application for bail, they have been told you are permitted bail provided you can access the conditions of bail. And of those persons who were not granted bail, it's only 331. So 71% of the remanded population who are entitled and have been granted access to bail, 71% of them are still there. When we translate that, Madam Speaker, into numbers, we did a conservative estimate of the cost of maintaining people in remand. And the cost ranges between $19,000 to $25,000 per head, per remandee, per month. And those costs are, of course, direct and indirect costs. Clothing, feeding, prisons officers to look after them. But when you start to add the indirect cost of transportation to and from the courts, of the prosecutors, of the magistrates, of the judicial system which articulates around it, we got the range between $19,000 to $25,000 per head. When we look into the statistics, 12% of the total inmates on remand have been there for more than 10 years. 12% for more than 10 years. 33.88% have been there for more than 5 years. And 54.09% of them have been there for just about 5 years and under. But when we translate that, Madam Speaker, into a dollar cost to the tax-paying dollars, so we know whole of government over 6 years, $15 billion in the police, $26 billion by central government. But let's look at the remanded cost population now per head. For the persons who've been there for 10 years and over, if you just took them at the 10-year marker, that percentage of 12% translates to $804 million at $25,000 per head.
If this was 10 years ago, surely at that time it wasn't 25,000 per head.
Sure.
Over the years, that amount increased.
Appreciate it.
I think the arithmetic may be a bit off.
Sure. The Honourable Member for Siparia has made a good point that this is a de maximis position. There will be a de minimis. I accept the logic in your argument that one should perhaps calculate what the mean average over time. That's possible to do. So let's be on the upper end of it, and I accept the criticism in the argument.
Thank you, John. I just want to find out, of the 839 people who are 839 people who are still incarcerated and were granted bail, what was the value of the bail amounts for those people on a range?
Sure. I'll come to that in just a moment. Let me just get through a bit of the particulars, okay?
Sure.
So I accept the point raised by the Honourable Member for Siparia, and on the maximum scale, we're looking for those there over 10 years at $804 million. For those who'd been there just for 5 years, not counting the average where they're between 6 and 10, we're looking at a figure of approximately $1.135 billion. When we look at the people who are under 5 years, we're looking at a rough figure on the upper end of approximately $1.085 billion. That's a fancy way of saying that the delay in justice is very, very expensive for the people of Trinidad and Tobago. When we look a little bit further, Madam Speaker, we see that of the persons who are incarcerated for bail, there are a range of offences. There are, of course, those who are there for very significantly important offences or serious offences like shooting or attempted trafficking in cocaine, etc., etc. But there are people in there for possession of small quantities of marijuana, for possession of a weapon or a knife, people in there for sacrilege, people in there for maintenance arrears, people in there for using obscene language, people in there for throwing missiles. all criminal offenses, surely a missile well aimed like David to Goliath could cause significant problems, I accept. But the point is that there are a range of offenses. Or a teacup. So, Madam Speaker, focusing and trying to get constructive work in the House today, Madam Speaker, we come now to the point of what is access to bail? Why should one even consider access to bail? Surely we don't want to be deemed to be promoting that, look, let's just get rid of remandees because it's expensive to do that. That's far from the case. In fact, the position is the balancing of rights issue. And when one looks to the balancing of rights issue, the mechanism inside of this is that it is a fact that the conditions of remand are very significant. I want to refer to an excellent report done by Daniel Kahn, who acted as Inspector of Prisons and produced a very thorough report in 2012. And in that report, the Honorable Madam Justice Gobin was quoted for her dicta in Colin Edgill versus the Commissioner of Prisons and the Attorney General, which is an unreported case, 3178 of 2004. And it jumped out at me. And this is the quote from Madam Justice Gobin at paragraph 31 of her judgment. The atrocities of the slave trade as well as indentureship are well known to us and have been part of our history. Some of the conditions at the remand yard are not so different from those experienced by our forefathers. In that context, I know my colleague, the Minister of National Security, will speak to the significant reforms which are going on at prisons right now, and I'll leave that thunder for him. But the point that I wish to make right now is that one of the aims, a laudable aim in promoting a better working access to justice system, is to deal with the reality that the vast majority of persons who are remanded come from lower socioeconomic brackets, some of whom are incarcerated in conditions where new offenders for relatively minor matters find themselves as cellmates, sleeping, as they call it, razor blade, meaning on your shoulder, can't lie down, flat on your back, in a remanded cell for very long periods of time. And there's an effect to that. And the effect is obviously multidimensional. On the one hand, are you causing an increase in recidivism? Secondly, are you breeding criminals in your jail who would otherwise not offend? Thirdly, when you remove someone out of the family support structure and someone is a provider to a family, what happens to that person left? Of course, that is counterbalanced against the rights of the victim and the fact that there is no guarantee for speedy trial under our Constitution, just a fair trial. But the point that we look at time and time again, be it Diosaran report, be it the many reports standing on the state and condition of prisons and the criminal justice system, we're seeing that we have reached breaking point and passed it a very, very long time ago. When one looks into the cause reasons for the inefficiency of the access to bail as currently stated in the law, chapter 460 before us now, we note that the mechanisms for access to bail are set out largely in the second part of the Bail Act. In particular, section 12 of the Bail Act deals with the processing aspects and milestones for processing bail. And when we look to that, we see that the current law, section 12 in particular, speaks to the two hallmark concepts that must be achieved if you're going to access bail. A judicial officer, considering the positions under section 6 of the Bail Act, then goes to section 12 of the Bail Act, looks at the provisions and says, you may be required to have a surety or security. Why? You are given conditions of bail, you are set free by judicial discretion, so that you can be warned that you must come back to the court to answer the case against you. The law currently provides that you must be subjected to conditions which include a surety or somebody who comes and guarantees by way of some, if I can use the word indemnity, that you will turn up. And that indemnity is put into something called a recognizance. And that recognizance is translated to a dollar value. And they say, look, if you're going to stand bail or be the surety for this person, you must be potentially liable to lose the asset which you pledge against this.
Put your money where your mouth is.
Put your money where your mouth is, as Siparia says. Secondly, you may have a security aspect where you physically have the opportunity to put forward cash security or land security, movable or immovable, actual land value or not. Because the law, whilst it doesn't define property or define surety or define security, there are references when you cross-reference section 19 of the Act to section 12 of the Act and then the schedules to the Act. You can see that we have the judicial perspective to have property in the form of movable or immovable. You can have surety there and recognizance provided. You can be released in a number of circumstances or a mix of them. And when we look to the surety, you can have bail with a named surety, or you can have bail with a surety to be approved by the clerk of the peace where the surety is not actually known at that point in time. But the law has grown up in the courts such that the judiciary now has a preponderance towards the insistence of land as the security to be provided under recognizance. And when we looked at that, we realize that of the prison population, the vast majority of them standing in impoverished and landless conditions, even though you have bail, we know from the statistics, 800 plus people out of 1,000 something have been granted bail but can't access it because they're landless, they're assetless. And therefore, the insistence for the provision of putting your land forward has had two consequences. One, we have kept the remand population in a constant state of stagnancy. And two, stagnation, thank you, malapropism and all. And two, we have turned a blind eye to an active and unlawful and illegal operation of professional bailers. We know, my learned friend from St. Augustine would know this well, that there is an offense prescription in the law as it stands right now that sections 18 and 19 of the Bail Act provide. You cannot agree to indemnify the person who is giving the surety for you. It's an offense. You cannot, as a bailer who comes forward and give land as surety, use it again without the permission of the court. But in our magistrates' court, standing on the pavements in Port of Spain, in San Fernando, in Sangre Grande, in Arima, in Tobago, there are professional bailers known to everyone who stand up there and have little side conversations in front of the courthouse or in the halls of the courthouse saying, I got sign for you. And these people turn up over and over again using a system of providing the deeds across multiple times. Now, how has that allowed to prosper? For a number of reasons. One, the magistracy has not been computerized. There is no record on a computerized system on a daily basis of dockets. Nobody knows on a day-to-day, minute-to-minute basis, as we have in the High Court, what a magistrate's docket looks like. It's a paper management system, which is why we were insistent as a government to put in the criminal proceedings rules, which came in effect in April 2017, because concomitant with that was the build-out of the judiciary's case management on an IT platform. So we're loading everything into the data management system so that you will know as a matter of reality where you stand in the cases, which judge has what the load looks like. That has caused some problems recently, we've learned. And the fact is that that's the system. But in that system, the professional bailers come up because there's no knowledge now of what property you have used in what circumstances, because the left hand is not talking to the right hand. The court downstairs doesn't talk to the court upstairs or the court in San Fernando, and therefore professional bailers have been allowed to prosper, Madam Speaker. It makes a nonsense of the entire system of bail. In these circumstances, That's why we are also driving the reforms on the compulsory registration of every lot of land and parcel of land in Trinidad and Tobago, and the opening of that access at the registry, as we're doing in the 4 bills now before us, not anticipating them, and in other bills which will come in September. You will see that we have a whole land package where the data on land is known. Why? So that we can make sense out of nonsense. We've spent billions of dollars as a country for umpteen years, but our systems don't talk to each other. And I've heard now for the second time in crosstalk, albeit quietly, a suite or architecture. Yes, if you don't have a bird's eye view of the connectivity of each of these areas, the registries being open, the registry in the criminal justice system being computerized, the left hand talking to the right hand, prisons with access to information on case management with the judiciary, motor vehicles with access to the treasury, with access to the court, with access to the police, so that you have a system of connectivity to make sense of our expenditure, to ensure value for money, then we are not in the correct direction. So, there being 10 minutes to debate the bill, very rare that I would take any advice from Oropuch East, but he's come good today. You see, the context of the bill and the rationale of the bill is now anchored in the context of Trinidad and Tobago and the mischief that we seek to solve. You see, this bill is a very short bill. This bill is exactly 6 clauses long. Short title, clause number 1. Commencement, i.e. that there shall be proclamation in clause number 2. The interpretation section in clause number 3. We're now dealing with 3 substantive clauses. Clause 4, which is an amendment to section 12. Clause 5, which is an amendment to section 17. And clause 6, which is an amendment to the schedules for the introduction of a 4th schedule. What are we talking here in clause 4? Clause 4 of the bill deals with allowing the legislative statement of the forms of security that are now acceptable. And specifically, when we look to clause 4 of the bill, we are prescribing in a new clause 4A that you can use cash, certified check, where the amount is under $10,000 or less. And there's a direct conversation that I'd like to hear from the opposition on the concept of cash. You see, we've prescribed in the new 4AA, cash can be used for $10,000 or less. Why have we stated 10,000? We are linking it to the money laundering provisions where you make declaration of cash, etc. But there may be an odium in the use of cash. Because the question is going to be, are you going to have somebody, and I'm going to put it raw, rob someone, get the $10,000 in cash and turn up at the prison and say, here you go, let me go. Where did you get the money from? What's your source of revenue? What's your source of income?
Well, you could deposit $150,000 in a bank.
Or you could deposit money into the bank and have...
Members, could we please control the crosstalk? Every member will be allowed an opportunity to make his contribution.
Madam Speaker, you would note that I'm trying my best to raise and elevate the level of conversation in this Parliament. I'm trying my best. Again, tested a little bit. But anyway, you can, in fact, put cash into a bank, fill out a source of declaration, and then draw a certified check. But clause 4 of the bill, which amends section 12 of the Act, allows us to use cash and certified check for amounts below $10,000. You can use a certified check where the amount is greater than the security of $10,000. And we're prescribing as well that you can use a bond. The word, in fact, should not be, and I'd propose an amendment of a registered financial institution, should be a licensed financial institution, allowing for a bit of flexibility in the type of institutions which you could access. Or you can have a charge on immovable property, meaning land. We are also allowing, in terms of the insertion of a new 4B, that bail can be granted to that person who stands to give the security or to the person who comes forward, and that when the court actually closes, because you've missed the 3 o'clock cashier deadline, that you don't need to be worried about the working day close of cashier at the court. If you've got the security as approved in the form by the judicial officer, you can actually now access the prisons, which can receive the form of security, issue a receipt for it, return it to the inland revenue into the consolidated fund via acknowledgement through the court the very next day. So that we're improving the times for accessing the conditions of bail, which is where clause 6 comes in, which is where we amend the schedules by adding a fourth schedule to prescribe the times by which you can access the payment of these forms of security or lodging of security. When we look to, of course, the mechanisms that flow in 4C in clause 4, again, it's just what I referred to, which is the fact that you must have an accounting system by the prisons when they receive the forms of security, issuance of receipt, and repayment across to the correct positions. But I ask you to bear in mind that cash can actually be paid by links or by credit card, because you have, of course, the exchequer and audit provisions which allow for the payment by those mechanisms being tantamount to cash. Yes, in the courts, at the Registrar General's Division, at Immigration, at Customs, cash can actually be paid in significant ways. But rules of court and protocols between the Ministry of Finance and the courts can actually take into effect if we wish to have electronic payments of security. Clause 5 of the bill deals with the mechanism for improving the forfeiture of the types of security that we've actually put in, Madam Speaker. And when we're looking to the forfeiture provisions, there was the complaint that it was onerous and that there was some difficulty to it, and therefore, in our consultations, and I'll give you in a moment the persons that we consulted, in our consultations, we came up with an improved mechanism to allow for forfeiture to extend to certain values. We are proposing the repealing of subsection 2 of section 17. We're replacing it with a new subsection 2 which captures what the old subsection 2 did, but goes now a little bit further and adds that the forfeiture can actually be less than the amount. The defendant can actually have 7 days to show why that forfeiture should not be made, so you can show cause why. And we're adding in now the concept of paying the sums already put on security, that cash or certified check or lien on land or bond as it comes from a financial institution, that there can be an election by the defendant to have those monies used for the reparations, if I put it that way, for payment of fines ordered by the court or compensation to victims. Clause 6, of course, just simply deals with the amendment of the schedule by inserting, as I said before, a fourth schedule. So it's a rather simple bill. I'd like to add, as we draw close to a close for this piloting of this debate, that we did consult with the Commissioner of Prisons, with the Judiciary, the DPP's office, the Criminal Bar Association, and the Law Association. In particular, I can say that the judiciary had fulsome responses, in particular in relation to the forfeiture and security provisions. The Commissioner of Prisons was fulsome in response as well. Regrettably, notwithstanding attempts to get a certified position from the DPP's office, the Criminal Bar Association, and the Law Association, I can tell you that we wrote the DPP's office on 5 occasions between July 2016 and January 2017, and several follow-up phone calls. We've got nothing back. We have also had letters written to the Criminal Bar Association, again July 2016, straight up to December, and umpteen phone calls. Nothing back. From the Law Association, July 2016, September 2016, January 2017, January 2017, February 2017, and constant calls and meeting with the councils, nothing back. So, perhaps they knew you were going to speak in the debate. So, the fact is that we have made attempts to obtain the responses and views of several persons. We have certainly made constant inquiries into that fact. I'd like to commend this bill to Trinidad and Tobago through you, to all members present, Madam Speaker, as one which is due, as one which is necessary to deal with the ills of our society. I'd like to add that it, of course, coordinates with the operationalization of the electronic monitoring system, so that if you are released on bail or conditional release, that there is a mechanism for electronic monitoring, which the Minister of National Security will speak to, so that it isn't just that you're letting people out. What you're doing is facilitating the judicially approved access to bail and looking towards a balancing act for the people of Trinidad and Tobago. I look forward to the views of the opposition on this material, and I beg to move.
Honorable members, I shall now propose the question for debate. The question is that a bill entitled An Act to Amend the Bail Act, Chapter 460, be now read a second time. Member for Siparia.
Thank you very much, Madam Speaker. I joined this debate not to congratulate the Honorable Attorney General, who sought to create the impression that this piece of legislation is due, and provided a host of reasons why it was necessary. But, Madam Speaker, I intend to show in the limited time allotted to us, and my colleagues will follow thereafter, that this bill is a retrograde bill. This bill, in many aspects, contains unconstitutional provisions. The bill also contains exceedingly flawed drafting in terms of the ends that it seeks to meet. The bill will not achieve the aims, the objects and purposes that the Honourable Attorney General has put forward, and which is contained in the explanatory note of the bill. And the Honourable AG said he has not had the benefit of consultations from the bodies, the stakeholders, which through no fault of his own, and so we give him credit for trying. But perhaps if we had had some of that, we may not have fallen into the errors that we find in this bill. Madam Speaker, this bill, you know, we say with a motion it is frivolous and vexatious and totally without merit. I would say that this bill constitutes total, unadulterated legal dotishness. And I intend to show why I'm saying this retrograde, unconstitutional, fraud in drafting, will not achieve the aims and objectives and purposes set out in the explanatory note of the bill. First of all, there is a movement in the world right now, and the movement is one that is moving away for what is termed as money bail. Money in terms of whether it be as cash bail, certified checks, or property, whether real property, which will be movable property, furniture, chattels, and so on, or immovable property, your land, where deeds are required. There is an entire movement away from that. And in fact, when we look at the history of bail, which dates back really from Roman times, but for us is over 1,000 years coming down from the Anglo-Saxons down through the British and to us, the whole bail system developed. It was not for you have to pay money to get your liberty. The purpose of the bail when it initially started was not to pay bail, pay money for liberty. But that's where we have gone. And in the United States, they went totally into money bail, an entire industry. AG spoke of professional bailers and so on. In the United States, it's in fact by statute that these bondsmen, professional bondsmen, operate, and there's an entire industry in that regard. But there, that is where they have the extreme of it. They are moving away completely from money bail. And I would like to read a short quote with your leave, Madam. And this was in about 1963. For 175 years, the right to bail has not been a right to release. It has been a right merely to put up money for release. What has been made clear today is that our present attitudes toward bail are not only cruel, but really completely illogical. Usually only one factor determines whether the defendant stays in jail before he comes to trial. And we are speaking about pre-trial justice, and this is where There's only one factor determining whether the defendant stays in jail before he comes to trial. And what is that factor? That factor is not guilt or innocence. It is not the nature of the character of the defendant. That factor is simply money. How much money does the defendant have? These words were spoken by former U.S. Attorney General Robert Kennedy in 1963. And as a result of his efforts in the United States, in the federal system, they have completely removed money bail as being one of the factors to obtain release. There have been several projects, the Manhattan Project, the Vera Project, several which moved away from money bail and used alternatives for securing liberty for pretrial justice. That conference then led to a major bail reform in the form of the Federal Bail Reform Act 1966. And what they did, they recognized there and they provided generally that non-capital defendants, and for us the capital offenses, murder, treason, and so on, where you do not get bail, non-bailable, once it was a non-capital offense, defendants were to release pending trial on their own personal bail, personal bonds, unless the judicial officer determined these incentives would not adequately assure appearance at trial. And thereafter, in all 52 states in the U.S., they have enacted law authorizing release of defendants on their own recognizance. So, this bill, I say, in putting out forms of security, and let us understand the difference between a surety and a security when we talk about bail, because in some ways people get confused, and in the AG's presentation, I wouldn't say it was confused, but it was not made clear. The surety is a person. In the days with bail, you will bring a family member, a relative, a neighbor will say, look, I guarantee, that's what bail was, I guarantee this person will attend court. That's the surety, the person. And then it developed into, they were not just taking the person's assurance that the accused would attend court on the days that he needed to or she needed to, moved away from that and said, well, you know, it's not enough for you to come to court and give an assurance that you will be the surety. You need to give something called a security. And so the law developed. Security became, could be your car. In those days, no cars. Could be your horse or your bull cart. Could be furniture, movable property, what we call personal property. It could be in the form of land, your land deeds and so on. And that system developed down to where we are, moving away from that personal assurance only to security for bail, to bring in persons into securing their attendance at court. So what the Honorable Attorney General presents in this bill are not one measures for access to bail. You know. So to start with, even the name, the title of the bill is wrong. It is wrong. What it sets out to do is to identify security for bail. The things that must be given to the court in order to get your freedom, your release, pretrial release. And the other provisions, which in Clause 5, I'll come to in a moment, so Clause 4 basically is just to identify. And you know what is very interesting? On the one hand, I'm sorry, yeah.
Thank you very much. Thank you very much for giving way. Since it is your view that the name of the bill is wrongly denoted, what do you propose that it should be?
I propose the bill should be completely withdrawn. And when I'm finished, I'll show why. So I'm saying starting from the very name, and as we go through the clauses, the bill should be completely withdrawn. I started off, and I intend to show that in the time I have left. So we have all the articles with respect. I'm saying in the world now, the movement is away from money bail, whether by check, whether by cash, whether by land deeds, and so on. Okay? We're moving from that. And you know, the Honorable Attorney General, really, it's this righteousness. Oh, these poor fellas, they're so poor in the jail, and they've been incarcerated, and they have bail. They've received the order for bail, but they cannot make the bail. How many of those 800 people inside there would be able to make the cash bail that you're now suggesting? How many? How many of those 800 people in remand who you say already got bail will be able to find the $10,000 in cash? Or more than $10,000 in a certified check? So it is not just simply a question that they do not have a land deed. Because right now in our law, Right now in our law, the different kinds of security for bail, all these things that are already there, handed down through the common law. Our Bail Act 1994 is silent as to what should be security. It is silent. Nowhere in the Bail Act does it say what should be security. But the judiciary and the magistracy has been granting bail. Own bail is called, with a deed. Cash bail, madam. Certified checks. All those things are happening as we speak. Yesterday there were about 20 applications for bail before the Port of Spain Bail Court here in the magistracy. And you know, people were coming and say, you know what I want? Can you kindly give me cash bail? They were asking for cash bail. My scholars can give us about, I want the alternative cash bail and so on. So every one of these types of security are there. You know what is interesting? And the security is mentioned here by the Honorable Attorney General in Clause 4. Does not mention at all, does not mention movable property, chattels. And you know that's happening right now. I was sort of a case where a lady came, a mother, with respect to her son and so on, and they have no money, they have no land deed, and said, okay, well, do you have anything in your house of value? And she said, yes, I have some furniture, I have a spoon. And the spoon is valued at $500. So, asked by the judicial officer, well, how could the spoon be $500? This is a real matter. How could it be? Well, first it started off being gold-plated, brass-plated, until, well, you know what? As a lawyer really told me to put $500 to make up the value. So it's cash bail, yes, in money, in certified check, or in personal property. One case of furniture, a photograph was brought, photographed nice furniture. Look, this is the furniture valued at X amount. I'm offering that as the security. When you check it out, you know, the judicial officer, but wait, that looks like a court signage. Wait, so, you know, people use, and that's a problem we have to solve. That is a problem we have to solve. The valuation of the properties, or the movable property, or immovable property, Israel and personal, that is a problem that is happening with bail. But that's another issue. So I'm saying now the whole movement away from money bail, and whether this bail will serve the purpose of getting these over 800 people on remand who got bail to get them out of bail. And it's my respectful view it will not, but there are other points, and we will come to those it will not. You may have some of them who could find the cash. But has any study been done, any statistics obtained as to how many of these are saying, you know, I cannot go because I just don't have the cash. I do not have a deal. How many of them? And then now, when we look, as I said, what is happening around the world, moving away from money bail already in Canada, in the United Kingdom and so on, you didn't have this severe development of a sort of total dependence on money bail. And I say money, I use it in terms of money to cash, or in monetary instruments in terms of a certified check, or in terms of a land deed and so on. And we look at the articles. I will not have time to read them, but my colleagues will take them up. But you get an article just last year in The Guardian of February 2016. Reforming the cash bail system should be eliminated rather than reform. And in this article, reforming the cash bail system to keep non-convicted poor people out of pretrial detention is the right thing to do. Article goes on with that. April 2016, an article here in the Atlantic, April 12, 2016, the dangerous domino effect of not making bail. Again, you can't find the money. You're told to get the money. All kinds of nefarious activities go to get the money or the certified check, as it may be. When low-risk people enter this maze after arrest, pre-trial policies can ruin their lives. Detaining the poor, another article, May 2016, detaining the poor. How money bail, and I'm using money, not simply cash, but the instruments, perpetuates an endless cycle of poverty and jail time. One reason that the unconvicted population is so large is because the country has a system of money bail, in which the constitutional principle of innocent until proven guilty only really applies to whom? The rich. The rich. It is those who could pay with the deed or with the monetary instrument, they will go on this bail system that we have. And so this bill, I'm saying, does not take that into account, but yet the Honorable Attorney General is talking about poor people inside. He talks about somebody in for sacrilege. I know the case, you know. A fellow over 60 years on sacrilege. When I heard about it, I said, I don't believe we still charge people with respect to sacrilege. This guy has been in there for years. And Madam Speaker, the sacrilege was he broke down a church door. He broke down a church door, which is really sacrilege to do a thing like that. And so he was charged. And I think he was further trying to pick up some of the items in the church. So there would have been some trying to take what was not his, but at the same time to break. And he's been in there, and you know, for how many years? He's already served almost the max of the sentence that he would get should he be found guilty at the end of it. But because of the delays in the system, no trial, and therefore he's inside. What do you do with that person then? On an offense that will be in some senses minor, already serving his term, and I haven't heard the AG address that. I would suggest that all those persons inside who have been granted bail, can't get out because they don't have the instruments to get out, the judge has ordered the bail. Look, why don't you just bring all of them? If they've already served their sentences and no trial yet, just bring them and give them all bail. Give them all bail, because they've already been punished sufficiently. And there were issues, I remember, people discussing, well, the DPP will bring the nolle pros, but then there'll be difficulties if you say you're not prosecuted. Well, then a person who might have been guilty went away without a blemish on the record. So bring them in because of the failure of the state and the criminal justice system to provide a speedy trial and the long delays. You've already served out the term. Please just bring them before the court and grant them bail. One suggestion, but I'll have some others as we go along. Again, on this cash bail, October 2016, my NBC, cash bail, the centerpiece of the justice system, is facing its undoing. And what is happening as we speak now in California? There is filed in the Senate in California, a bill has been filed to take away the California Money Bail Reform Act 2017. And this is where the promoter of the bill in the Senate says, the presumption of innocence is one of the foundations of the justice system, but every day thousands who are awaiting trial are forced to be in jail because they don't have the money to post bail. The current cash bail system is the modern equivalent of a debtor's prison. It criminalizes poverty, pure and simple, and that's not right. So the bill is before the Senate. I have with me a copy of the history of the bill, as we have the history of the bill, our bills. I've obtained a copy of it, and as recently, continues in April 2017, from the Oakland Post with respect to that bill, California bill to eliminate bail system clears its first hurdle, April 2017, where it was approved, that Senate bill. And then April 4th, 2017, bail reform legislation passes the first step, what is called a public safety committee in that Senate. And in May 2017, May 15, 2017, the California's bail system is unfair to non-wealthy, especially if they are innocent, and that bail, as of the 15th of May, has been placed on a special committee, the Appropriations Committee of the Senate in California, and looks set to go with respect to money bail. So that's one reason I'm saying it is retrograde, and we should be looking at bail reform in a more holistic manner, rather than punishing and really creating that domino effect on those who are already poor, that whether you pay it in cash, certified check, or land deed, you still cannot afford to pay it. The other issue with respect to money bail, Madam Speaker, is issues relating to constitutionality. And in the United States, there are several cases filed and that are pending now, where they're using an amendment to the Constitution, I don't remember the exact number, but it's one which deals with equality provisions. And in our own Constitution, we have the equality provisions in our Bill of Rights, contained in the Constitution, Section 4 and so on. And the issue arises is, if I am poor, I don't have a land deed, I can't get $10,000, I can't get $5,000, I can't even get $1,000. How many thousands are living below the poverty line with just a few $100s per month? And I can't get any of that. And I am being subjected to treatment that really discriminates against my condition, then it is unconstitutional. So these are the things happening in the larger world. And if we are really concerned about the prisoners, as we say, and they are not just prisoners as criminals, we must remember that a prisoner is presumed innocent until proven guilty. That is a fundamental tenet of our criminal justice system and of our democracy. So that is where we are in terms of the movements across the world. And this bail bill is coming back to confine us, not take us out of that, but confine us into money bail, a system that is fast on its way out in the modern democratic society. When we look at the history of legislation, we see two trends developing over the years with respect to bail. There is one trend which has to do with a movement from unsecured bail, which I spoke about already, by sureties, unsecured bail by surety, and we're moving to secured bonds by professional bailers here, in other countries, professional bondsmen. And then there's a second trend of development, which has to do bail or no bail. That's a decision that the judicial officer has to make. Do I grant bail or don't I grant bail? And having made that decision, is only then you go to that second stage of secured bail or unsecured bail. This bill deals with respect to whether secured bail or unsecured bail. And in our own jurisdiction, before our Constitution, and up to the 1994 bail bill, which is now our Bail Act, Chapter 460, I believe it is. What was the law? Honorable AG spoke of then Attorney General Keith Sobian, who piloted that bill in the Parliament in 1994. And for the first time, we got one statute only dealing with bail matters. Before that, and there's a judgment in the Court of Appeal, I think it is Sinanan and the State, number 1, and it is reported at the West Indian Law Reports, West Indian Reports 44 WIR at page 359. Our Court of Appeal there, Justice Sharma, Justice Ibrahim, and Chief Justice Bernard, gave a judgment in 1992, and the bail bill was passed in 1994. So the state of the law at 1992 was that of the United Kingdom. Imported under the Supreme Court of Judicature Act and under the Supreme Court Act and the Constitution Act, where it was saved law coming out of England, received law, if you may want to call it that, where all laws prior to 1962 received into Trinidad and Tobago from the United Kingdom. So what the 94 bill tried to do, and did not totally do, was to take up the common law and statute law that we received from the United Kingdom and to codify some of it in the 1994 bill. When, Madam Speaker, the bail bill 94 became the act of 460, chapter 460, is silent on many matters relating to bail. Many, many matters. So it is still that common law out of the United Kingdom which governs, for example, areas where the Bail Act, is silent, and these are, for example, it is silent with respect to a definition of bail. There is no definition of bail in the Bail Act. There is no definition of bail anywhere. The Constitution gives us the right to bail, to reasonable bail, but it's not defined. What is defined in the Bail Act, Chapter 460, is bail in criminal proceedings, but it is silent on the definition of bail. It is also silent on the various types of bail that may be granted, the types of bail. And it is also silent on what is the security for bail. Coming out of that then, the judiciary on its website has put out a definition which can only have come out of the common law. And on the judiciary website, bail is defined in these words. And this is in terms of really what would have been a common law. Pre-trial release. Bail is pre-trial release. It may be considered a contract whereby an accused person is released on certain terms from custody to his surety or sureties. The surety or surety's responsibility is to ensure the defendant attend court at every hearing. Then the judiciary website answers the question, what are the different types of bail? And they say, own bail, where you sign your own bail bond. Bail with a named surety. This is where a person is a named bailer, is approved in court, and you have to present a valid ID card, DP or passport. No form of security is used. So this is the bail with a named surety. Then it's bail with a surety to be approved by the clerk of the peace, and these are the kinds of orders that are made for bail. The documents needed, a certified copy of a deed, most recent land and billing taxes receipt, ID card, and so on. The person who is accepted as a surety or bailer must be approved by the clerk in terms of magistrate's court or by the registrar in the High Court. The judiciary website also says cash bail. This is another type of bail. The person who is presenting himself as a surety for the cash bail is required to show proof of the source of funds. This requires a production of a recent bank statement to the clerk of the peace or to the registrar. And the other type of bail that the website speaks of is police bail, where a senior police officer decides a person charged for a minor offense may be granted bail, and this usually happens where you're in custody during hours when the courts are closed. So what does it mean? Our courts are already given, as I said, the different types of bail, the own bail, secured bail, with the securities being cash, where you can give cash bail, or land deeds. So what is the difference in this bill, Madam Speaker? What is the difference that we now have? And let us go to see what is the difference as we look at clause 4 of the bill. 4 minutes to 50. 30, thank you very much. Okay, let's see clause 4. This is explanatory note. In clause 4, section 12 of the Act is amended by inserting after section 4, subsection 4, the following subsections. Please take note, section 12 of the Act is amended by inserting after subsection 4, the following subsections. 4, capital A. The security given under subsection 4 may be in the form of cash or certified check. Security is 10,000 or less. Certified check, security is greater than 10,000. A bond from Malaysia now says a licensed financial institution under the Act, Chapter 79, it charged on immovable property. Note, it doesn't put personal property, so that is left out. And we don't see anything here with respect to own bail, where you sign your own bail bond, which is the simple, those are the simple ones for the poorer people. Not the cash, own bail, and of course, your furniture, other kinds of personal property that you have. Now, this is very, very dangerous what is happening here. I said this bill is so badly flawed in its drafting. The insertion of this section, we need to go back and look at where we are inserting it. And I mean, I'm flabbergasted that this could have come through to this Parliament, where it is so badly, badly drafted that it just applies to a small category of prisoners. It doesn't apply for security, for bail, for the majority of prisoners, but a very minor category of prisoners. So let's see what clause 12.4 says, because we're inserting after clause 12.4 this 4 capital A. Clause 4 of clause 12 of the parent bill tells us.
To West, please. Yeah. So clause 4 of the bill asks us to insert in section 12 of the bill, and this is where section 12.1, a person granted bail shall surrender to custody. 2, a court may require any person applying to provide as condition for bail a surety. 3, a court may require to surrender passports at certain conditions. And we come to 12.4. 12.4. 12.4 reads, where it appears that the applicant for bail is unlikely to remain in Trinidad and Tobago until the time appointed for him to surrender to custody, he may be required
before being released on bail to give security for his surrender to custody. And this security may be given by him or on his behalf. This is only for persons applying for bail where that person is unlikely to remain in Trinidad and Tobago. This is not for any applicant for bail. And now you want to insert 4A, which says the security under Section 12(4) shall be cash, certified check, deed, movable property. Madam Speaker, this is madness, this is nonsense. How many people out of those 800 people that you say are remanded who got bail are persons who are unlikely to remain in Trinidad and Tobago? Are they Venezuelans, Bajans, Jamaicans? How many? This is totally being inserted in the wrong place in the bill. It's being inserted where 12...
Your original 30 minutes are now spent. You're entitled to a further 15 minutes to continue if you wish.
Yeah. Yes, thank you very much, Madam Speaker. So this is totally, maybe because the word security was in Section 12 of the main Parent Act, they said, hey, what is a security? So now in 4A, where we are dealing with Section 12(4) of the Act, security, the word security now means these various things. What legal, I don't want to say dotitious again, but this is so totally flawed. Doesn't belong. What will it do with your 800 persons on remand or anybody else? They will still have to use what is at present defined and put out by the judiciary as obtains coming as received law out of the United Kingdom. That's nothing new for the majority of persons. There's only one category of persons. Now, there are a whole host of issues which deal with cash, and I will leave that to my colleagues too, because time will not permit, because it's another very important matter I would like to raise, and it has to do with all the dangers with cash. I will go to, with respect to cash. Madam Speaker, you may or may not know that the United States has put out, what do they call it, International Narcotics Control Report, INCSR report, in March 2017. And out of 196 countries, Trinidad and Tobago, along with some others in the Caribbean, we are now lumped into what is known as major money laundering countries. What? Major money laundering countries. I've heard the government say this is not true, it's a lie. If you look at volume 1 of that report, at page 5, my time is very limited, sir, and you're winding up, please. Volume 1 at page 5, Trinidad and Tobago now lumped with some other countries out of 196 as a major money laundering country. The volume 2, page 6, 8, and 25, time will not permit me, but again, this is serious cause for concern. And money laundering relating to what they're talking about, all the things the Honorable AG tells us all the time about the FIU, and that the Honorable AG is the chairman, I believe, of the FATF, and he goes back and forward to deal with these issues. And here we are, for 2016, you know, because the first thing I'll jump on said was for 2015, no, this is for the 2016, we are lumped in as a major money laundering country, together with several of the CARICOM. And indeed, several CARICOM countries are also lumped in this net. And my respectful submission would be...
I'd like to hear the contribution from the member for Siparia. Please continue.
My bulk of stuff. My contribution would be that we, together with the other CARICOM countries, that we make statements on this. And indeed, some other CARICOM countries have already spoken out on that stigma, that demarcation, that we are, together with them, amongst money laundering countries. And so here we are now on the whole issue of cash bail and the whole issue of source of funds. And some complaints that people are making is when they go to the magistrate's court, they're asking about source of funds, and you need to bring a bank statement for 6 months. Similarly, to get the certified check, no bank is going to ask you, let you walk in with $150,000 or whatever it is and just deposit it. You have to have source of funds. So if the bail is set in a certified check for $150,000, you have to show source of funds. So is it going to help people who already don't have the money? Will they go around and beg their family and friends, which is what many people do, to assist in raising the money? How will this help those poor people that we are talking about? Then we come to the constitutionality of the cap. Honorable AG talked about the separation of powers and not fettering the discretion of the judiciary. And I would like the Honorable Attorney General to consider with the same clause 4, the constitutionality of the cap being set, that the cash bail will be only up to $10,000. In my respectful view, following upon the judgment of Barry Francis, a very landmark judgment which the AG relies upon a lot, where 5 Court of Appeal judges sat to determine constitutionality of sections of the Dangerous Drugs Act. Following upon that, what is happening here is that there's no discretion being given to a judge or magistrate to consider individual circumstances before imposing the bail. So if it is that you have to give cash bail, well, you could only give up to $10,000. Why 10? Why not 11? Why not 15? And in that sense, it is arbitrary and it is offensive. There is no rational relation to the type of security, reasonable bail to the actual offense. It goes even further to be capricious because judicial discretion is being removed. You can only give cash bail for you can give cash bail only up to $10,000. $10,000. So you have fettered a discretion that resided in a judge or in a magistrate or judicial officer. So this is a provision, respectfully, which indiscriminately applies a mandatory type of maximum cash bail and leaving the offender to have to find security. This is gross and unfair and offensive to the principles of justice, rule of law, and cannot be reasonably justified. As I said, the dangers with bail, how much time I have? 1 to 4. 9 minutes, yeah. Before I get to some suggestions, I want to look at clause 5 of the bill, which is also, in my respectful view, totally unconstitutional, should not be forming part of this bill, and should be struck out. Clause 5 tells us, where a defendant has been granted bail and the security has not been forfeited, this is clause 5, clause 5C, by inserting after subsection 4 of the parent the following. Where a defendant has been granted bail and the security has not been forfeited, the court may, if the defendant is convicted, order that the security be applied towards the payment of any fines imposed on the defendant if the defendant elects to pay the fine. So you're going to take money that was put up for bail to secure your release, and you're saying, no, listen, you now have to take that and pay fines first. Or you pay any compensation ordered by the court for victims. This is deprivation of property without due process. It is in contradiction of Section 4 of the Constitution, of the right to property, and not to be deprived thereof, except in the same circumstances the Honorable AG spoke of in Section 13, with respect to having the 3/5 majority and being reasonably justified. How can you take money that was paid into court for the purpose of releasing you on bail, of setting you free for pre-trial release, and then say, just by a simple act of Parliament, come and say, you know what, I'm going to take that money. What about when if the money was put up by a third party, a surety? You're going to, when that person signed that bail bond, that I guarantee I will pay the $10,000, I guarantee the $150,000, I guarantee my land deed for $500,000. They did it to secure what? The attendance of the defendant in court. And this is where the bail has not been forfeited. It meant that the defendant attended the court. I did my part of the contract. I attended the court. I made sure this accused defendant that he went to court every time he had to go. And I did all that I had to do. And guess what? Simple act of Parliament. You now want to take away my $500,000 to pay compensation. It is laudable, you know. It is laudable to want to pay compensation. It is laudable to use it to pay the fines. But because it is laudable does not mean that it is lawful. It is totally unconstitutional. Totally unconstitutional, and therefore clause 5 also in this regard has to be struck out. So we have constitutionality issues with clause 4. We have issues with clause 4 so seriously flawed where it is placed in talking about section 12(4), which is only where the applicant is unlikely to remain in Trinidad at the time of his release up to the time of the hearing. Not even at the hearing, you know, in that interim period before the hearing, he's unlikely to remain. I mean, you could have a student at university, for example, come here from Barbados to study, and then Trinidad studying, and okay, some minor offense happens, he probably had an obscene language case or something, and you know, it's unlikely he has to go back to his home country. Unlikely he will remain between now and the date of trial, but he'll come back for trial, so he gives the security and so on. You give one of these securities, that's what could happen. But all these persons cannot fall into this category, so I'm saying it is seriously flawed in that regard as well. And in the few minutes left, we talk about prison officers. I mean, prison officers are great people, but there are always those with the propensity to be not great and to abuse the system. You had keys missing. Am I correct? The keys missing in the prison. You want to deposit cash into the prisons, man. You want people going there up to 6 o'clock with money in their pockets. And don't tell me it's only up to 10, because a person could have several charges and they could choose to have a cumulative kind of way, 10,000 for charge 1, 10,000 for charge 2, 10 for 3, 10 for 4, adding up to $50,000 or $60,000, going down to the prisons were all denied. Who is signing for it? What systems are in place to ensure the integrity of any deposits made? So I have serious problems with prisons, and I think that is a recipe for disaster, to have cash being deposited there. Solutions? Some solutions. The issue of professional bailers, the AG spoke a lot and cried about it, and it's very, very bad. Has any single professional bailer committing fraudulent document, has anybody in this country ever been brought to the courts for being fraudulent in their dealings with professional bail? And whilst it is an offense under the law, has anyone been charged? So that is another major issue that has to be dealt with in the context of looking at bail reform. There was a mayor of Arima, I think his name was Mr. Ghassan Yusuf. Would you believe this mayor, whilst he was a sitting mayor, Madam Speaker, his deed found its way into a court and was used as bail, as a deed, as a security for bail by someone. And what happened is the bailer and the defendant did not take him at court. And the judicial officer sent for Mr. Yusuf and said, well, hey, you gave the surety, what's happened here? And he said, look, I know nothing about this, absolutely nothing. That's when he was a sitting mayor, the fraudulent use of documents. Again, AG speaks a lot about the IT and the technology and the networking. That is a serious matter that must be addressed at the earliest opportunity. So all of that, those are other issues that would arise. Oh yes, the traffic offences. AG, please just bring the bill dealing with the traffic offences. You will knock off half the cases in the magistrates' court. Yes. Just bring it. And we'll help you with it along the way. You will get half. What is it in, but it's in the Senate, but you haven't put it for debate. It hasn't been put for debate. Some suggestions. So one is the traffic.
We have another half an hour before the suspension. I'll ask members, please, to abide by the standing orders. Please, Member for Siparia.
Thank you very much. One, I've already made the suggestion. Well, I've made the suggestion of fast-tracking the traffic bill that is in another place at the moment. Let's get that going so we can knock off. And many of the reasons given were not the real righteous reasons about feeling sorry for prisoners and the suffering and the bad jail conditions. They were about expenditure. Too much money to keep them. Overcrowding. Those were some of the reasons advanced. Overcrowding. All these reasons. I don't ever have time for this, but I did have here coming out of the CSO, population expenditure, prisons 1999 to 2010 for every year, showing the differences in how much was actually spent. Strange enough, after 2010, no statistics have appeared up to today as to expenditure. Solutions. So first, persons who are on remand, they have spent close to or in excess of the statutory sentence for their respective crimes, be brought before the courts and granted bail. This will not apply to accused persons who are charged with non-bailable offense. I've made that point. Secondly, we need to spend a little more time with pre-trial supervision and monitoring. There was a great program started by Justice Kamla, now His Excellency, and followed through by Justice Holdip. It was called the Bail Boys program. It was a bail supervision court, and they would take the young ones, and then they extended, took the age up, it was up to 25, then they say up to 35. So there was bail supervision on pre-trial releasing on bail that spent time, and that had helped tremendously in ensuring persons came back to court and so on. In addition, there were courts established to monitor compliance with conditions and restrictions attached to bail orders. That's another thing. There's no networking. There is nothing that gives you what happens when I put all these conditions on you. Who reports back if you keep the conditions? So we need to spend some more resources to institutions such as the Piparo Empowerment Center, the New Life Drug Rehab Center, Tobago Rehab Empowerment Center, and the Probation Office. These are some. I'll give it to others. I say this bill should be withdrawn. I thank you very much.
Member for Laventille West.
Madam Speaker, we have just been regaled with, we have just listened to a rather frenzied, confused attack, discombobulated attack on a measure that has so much value, so much potential for improving the current system. I am absolutely amazed, though not surprised. Because clearly, Madam Speaker, the opposition, led by the member for Siparia, has one purpose, and one purpose alone. It is to oppose anything that is good for the people of Trinidad and Tobago. It is the most frenzied and wild and confusing attack on solid measures that I've ever heard in my parliamentary career. So, Madam Speaker, let me attempt to bring some sobriety to the discourse again. The purpose of this, the Bail Access to Bail Amendment Bill 2017, is as clearly stated in the explanatory note. And for the benefit of those who would have listened to this frenzied attack, let me read it again. The purpose of the Bail Access to Bail Amendment Bill 2017 is to amend the Bail Act, Chapter 460, to facilitate a move away from the use of property as a means of providing security for accessing bail, and the introduction of the requirement for security by way of upfront deposits of cash or certified check. It is as simple as that. The member for Siparia, though, describes it as unconstitutional, as though she is the final appellate say-so on the matter, as though the member is the final appellate say-so. I want the public to know, when it hears a statement about unconstitutional, that is an opinion coming from the member for Siparia, and in my view ought not to be treated too heavily. It should be treated with short thrift. She described it as flawed, and the reason is because where the amendments to Section 12 are being, of the Act, the Parent Act, is being placed, it is inelegant. It ought not to be there. Without an understanding or an acceptance even, without an understanding that as a matter of law, every provision in the law, every section stands on its own. When a person is charged for an offense, it is in accordance with Section A, B, or C, or Section 1, 2, or 3. It doesn't matter about the others. And makes a point about whether it's elegant or inelegant. That is a moot argument in a serious debate on a serious matter. It is frenzied and ought to be rejected. So let me say, the member described it as total, unadulterated dotishness, trying to get a playback on a description from my Prime Minister on the question of dotishness recently. But it went nowhere. It went nowhere.
Members.
And I I'm sorry.
Members, I know it's quite close to the suspension, and members may be forgetting where we are. We're not as yet in the tea room. I'd ask you to display the decorum this chamber requires. Please, member for Laventille West.
Thank you very warmly, Madam Speaker. I quote in aid some lines from a song by one of my favorite artists, may his soul rest in peace, Peter Tosh, a beautiful conscious singer, who's in a song called Vampire, makes the point, they fight against morality, fight against integrity, fight against everything that is good for the younger generation. Call them vampire. The property tax is an example. Just moving forward, the people are willing and lining up to pay the tax. The opposition opposed to that. But let me deal.
Member, I'm sure you'll move on.
I'm obliged.
Thank you.
Let me go straight to the measures in the bill. But before I do that, the member calls in aid in her frenzied presentation circumstances in the United States. Those circumstances are manifestly different to ours. And our laws are different in many ways. Their mores are different. Their circumstances are different. And therefore, our bail regime is likely to be different. In the United States, you could buy a gun in every corner shop. Not in Trinidad and Tobago. Yeah. At least legally, and we deal with it legally here, and treating with the illegal. So I don't want to spend too much time about what, but the member confused me now, because the member tells us that the only factor that determines whether a person stays in jail or not, based on American research, is money. Well, the question the member for Siparia raised, does the person have money or not? And in the United States, the member argued that they sought alternatives. For non-capital offenses, they went to personal recognizance, where the person signed their own bail. And I take it that for capital offenses, no bail at all. The member raised those matters. Let me get into the provisions of this. Clause 4 of the bill, in attempting to amend Section 12, says, Clause 4A, Roman 1, subsection 4A provides for the forms in which security for bail shall be provided. Well, that's clear. Roman 2 says, subsection 4B seeks to provide for a person acting on behalf of the defendant. So the defendant is in custody. He cannot act on his own. So a relative or a friend or some concerned person for the defendant is acting on his behalf on the outside of custody. It goes on to say, who has been, acting on behalf of the defendant, who has been taken into custody to give by way of cash or certified check to a prison officer. This, to my mind, Madam Speaker, makes the current regime far more liberal. Because today, you have to give this cash to the court. And you have to do so before 2 or 2:30 when the cashier closes operations as a matter of public service regulations. Yeah, Madam Speaker? So now, it broadens it. It makes it more liberal. You can now pay this cash to a prison officer, presumably at the prison facility. So if you don't get the bail negotiated by 2 or 2:30 or 3 o'clock, you have no chance. You spend the night in custody as it now exists. But now you could go to the prison and you can do that. And let me tell you, in Schedule 4 of the bill, in the schedule to the bill, which treats with this, Clause 6 says the act is amended by inserting after the third schedule the following schedule, and this will be the fourth schedule. And it says day and times during which persons may give security at the prisons. It now extends it, so it's Monday to Friday from 8 a.m. to 6 p.m. That is 3 hours more than you would have had in the courthouse to avoid spending the night. And it further extends it to Saturday as well, making it more liberal, as I have argued, from 8 a.m. to 4 p.m. So you have liberalized the regime in terms of place, not the court alone, but the prison too. You have liberalized it in terms of time, given an additional 3 hours each day and Saturday. And of course, Madam Speaker, the member for Siparia, in a frenzied attack, tells us that this is wrong and this cannot work. It also, the clause 4 that I was reading in Roman 2, let me continue. So it says, by way of cash or certified check. As it now stands, Madam Speaker, a young man appears or a woman appears before the court. The court fixes bail and says surety to be approved in the sum of $200,000 or $120,000. That is plenty money. They don't have it. Notwithstanding that, unfortunately and misguidedly, they go robbing people around the place, which I, as an adult and a member of parliament, call on the young people of this nation to stop and cut out. Trinidad has too many powerful, positive opportunities to earn a legitimate income to do that and hurt people in doing it. So, they go and they do it. The court fixes bail in the sum of $120,000. They don't have the money. Granny don't have it. All the friends who they went and robbed with don't have it either. In fact, they're not even showing up at the court. It's only Mommy and Granny going to be there. And in a few cases, unfortunately, Daddy. So the court says, we know you don't have the money. So there are professional bailers around with deeds, and in some cases, false deeds. A serious problem, but not relevant and germane to what we're discussing now. And I heard the member for Siparia tell us that something ought to be done urgently about it, while she sat as head of the cabinet and head of the National Security Council and did absolutely nothing about it for the last 5 years and 3 months. And that's why I call them vampires and hypocrites. What's your plan? But let me continue. Let me continue.
Yeah. Withdraw that one.
All right. Well, it was just a metaphor, Madam Speaker.
Right. But I'd ask you to be guided.
I'll be guided. Yes. Yes. It was just a metaphor, an appropriate metaphor. Let me press on. Yes. Let me press on. So, Madam Speaker, I'm being disturbed by the member for Carinese. You know, he looks like he wants to. Yes. Yes. So it now liberalizes it further. So the man is now called upon to find, so the professional bailer, as I was saying, he is here now lurking around the court because he has a deed, whether bona fide or otherwise, but he has a deed. And he's prepared to make this deed available so that the man could access his bail. But he says, I need 10% of the bail amount in cash. So if it's $120,000, the family, as it now stands, will have to find $12,000, which is 10% of the 120, or $20,000 if the bail was $200,000 to give to him. So the cash transaction is already with us for a long time. What the Attorney General is proposing, what the government is proposing today, that rather than give the private bailer, the professional bailer, the $20,000 or the $12,000 in cash, you pay it into the court or you pay it into the prison, with the liberalized regime as I have just described it. And that is what is happening now. There are problems with the bailer. Very often when the bailer shows up, the professional bailer, he or she is now well known to all the courts in Trinidad. As a matter of fact, they have a list of some of them who are not permitted because of their behavior to access bail for anybody. So the court, wherever he presents this deed, spends the next 2-3 days, sometimes a week, checking on the document to see that the title is a bona fide one, on the one hand, to see as well that it has not been used in a court in Siparia or in a court in San Fernando or in Arima, and now you're presenting it as though it was never used in security in Port-of-Spain. And as well, they also spend time checking on the bailer as a person, because some of them are whitelisted. To be politically correct. So the thing continues. I mean no offense. I mean no offense. Yes. So the definition, the thing. So Madam Speaker, I'm demonstrating to you.
Right, San Juan. Please continue, Laventille.
The member for Siparia continues her frenzied attack from her seat, which is wrong. Calm her down, Madam Speaker. Yes, Madam Speaker, and the definition I was reading. So it says I continue. It says and I continue. By way of cash or certified check to a prison officer designated to collect same by the Commissioner of Prisons for that purpose. And hear what the last words of this provision says. Should that person be unable to pay the said security into court due to time constraints as I have just described. So this provision alone, clause 4A Roman 1 and 2, completely liberalizes the entire existing regime, and therefore I, as Member of Parliament for Laventille West, on behalf of some of the persons who are caught in this scenario, and for all the people who can be charged for an offense in Trinidad and Tobago, innocent or otherwise, I support this measure ab initio. Starting with that. And then I proceed to Roman 4 of the same subset of the same clause 4, which reads, subsection 4D would seek, well, the explanatory, subsection 4D would seek to provide that the Commissioner of Prisons ensure that a proper record of all bail monies received is kept. So he issues the Commissioner of Prison or his delegate, an officer, he issues a receipt upon receipt of the cash or the certified check as the law will now mandate. And the reason for that is the person with this receipt could demonstrate to the court when he or she appears on the next occasion that I have secured my bail and this is the evidence of my having so done. In addition to that, no doubt, it is to protect the prison service from issues of mismanagement with cash, not unknown to Trinidad and Tobago and other parts in the world. So a proper record has to be kept. And I commend the Attorney General for going this far to ensure that the regime works quite well in the circumstances. And Madam Speaker, I'll take the opportunity to make the point that the Attorney General is fond, because of his psychology, because of his thinking as a member of this government, as its legal advisor, we are abjectly and out against corruption and money laundering and thieving. So the Attorney General finds himself from time to time dealing with FIU issues and money laundering. They criticize him for that. I tell you, they don't want nothing good. They criticize him for that. But that is his psyche, that is his training, that is because he's a part of a PNM government. It's so we the stink. It's so we the stink. Criminals don't like police. Good. I know some cabinets were criminal too. But that is not the point. We'll deal with that in another place. The point that...
Could you all please stop the crosstalk? Please continue.
Thank you, Madam Speaker. The Attorney General proposes here quite sensibly and persuasively, in my opinion, hence my support, that if it is 10,000 or less, you produce cash to the court or cash for your bail to the prison and you get your receipt. But anything above that should be in the form of a certified check. It is because once it is going to be above $10,000, issues of scrutiny of the bank, authenticity of the document, large sums of cash for FIU issues will become relevant. And therefore, rather than come with 100,000 if the court sets cash bail, because if you are caught with 700 million kilograms of coke or 700 kilos of cocaine, and the bail is $1 million, you're not going to show up with $100,000 in cash just so. We want to know a lot. So there has to be a paper trail, and it is sensible and persuasively so to have done more than 10,000 by way of certified check, and I commend the Attorney General for that. It's another check and balance. It's another check and balance. But the member for Siparia has a problem with that, with checks and balances. She always has a problem with checks, and the member has, and my friends on the other side, and my friends on the other side, and the country knows why. That is why they treated with them on September the 15th. That's why they treated with them in the manner that they did. So I think that is a very sensible provision, and as I said, it has to be commended. Right? So, Madam Speaker, yes. Yes. Madam Speaker, the member for Siparia asked, how many people will be able to meet cash bail? And in the same breath, immediately after, juxtaposed closely to it, the member tells us that only yesterday there were 20 persons appearing in some magistrate's court making applications for bail. And the member bold-facedly, after wondering how many people will be able to pay, tells us in the same breath that of those 20 people, most of them were asking the court for cash bail. Do you remember, Madam Speaker? And that's why I described it as frenzied, knock-kneed, confused and twisted, tight-tongued too. In the same breath, implying that how many people will meet it, but witnessed yesterday and told us so unashamedly that most of them were asking for cash bail. And why? Because they consider it more accessible to them. Instead of paying the professional bailer and all of the hoops they have to go through for a week with the checks and all of that. And sometimes you pay the professional bailer, and after he takes your 10,000 or she and disappears, when the court conducts the check and you appear on the next occasion, the court said this deed is not a valid one, or that bailer was not an appropriate person for this, and recoup the take back the bail. And then the person in custody again, and when the mother or father or aunt or granny go to find the bailer, his address is 29 Port of Spain, or light pole number X, Mayaro Road, Naparima Mayaro Road, can't find him, no house there. So there has been a lot of pain and a lot of loss in this whole bail regime. And the measures proposed by the Attorney General are a direct attack on the confusion and intended to make it more efficient. I commend the Attorney General again. But the member for Siparia has a problem with that. Peter Toshall again. So, Madam Speaker, all the other things that the member told us, in my view, including that we cannot expect their support on this measure, because rather than tackle this measure of bail and securing it in the way that is now proposed, we should come with a holistic bit of legislation on the question of bail. Whenever they want to obfuscate and obstruct, and they want to run away from that which is good for the people of this country, that is one of the things they say. You need to come with a holistic approach. But with all the holistic approach, they passed a bail amendment bill allowing people to remain in custody for 120 days, which expired since we are in the government. Kidnapping. And when we came back here with it holistically, they opposed it holistically. And it doesn't exist today. Yes. And calling for statistics. Well, we have some statistics in front of us through the lips of the member for Siparia. She told us there was a sample of 20 people who appeared in court yesterday. And of the 20, most were asking for cash bail. You can't get more live statistics than that, anecdotal as it is, if the member for Siparia is to be believed, which is a risk in itself. I'm sorry.
Insulted, Madam Speaker. 48-6.
My leader. That's the kind of person he is. Totally offensive.
Member for Laventille West, I just ask you to retract that last. 1 minute, please. 1 minute, please. Member for Siparia and member for Naparima. I I appreciate your interest in this debate and your passion. Member for Siparia, you've had your opportunity, and I'm sure you can pass on other matters you would like to be ventilated to the other speakers.
Madam, he's been offensive.
Member for Siparia, I'm on my legs. I dealt with the insulting. I've asked the member to retract. This is separate and apart. As far as Member for Naparima also, you haven't had your opportunity to speak in this debate, but I assure you, when the time comes, once you catch my eye, you'll be given that opportunity. So, Member for Laventille West, could you please retract the last part formally for the record?
I retract without more. In fact, if I hurt the member for Siparia's feelings, I withdraw it.
Siparia. Member for Siparia. Yes. Member for... How many persons want to be in the chair? Member for Laventille West, I would ask you to retract without any further statement which may appear to undo the retraction. Please.
I withdraw, I retract without undoing, Madam Speaker. Madam Speaker, let me remind the member for Siparia, when the member led the cabinet in March of 2013. I have in my hand a cabinet minute number 612 of March 7th, 2013, in which cabinet agreed, and I am quoting, to approve the policy document for the amendment to the Bail Act, Chapter 460, a copy of which is attached to this cabinet note. Madam Speaker, this policy document, and the public must know, whenever there are proposed changes to legislation or introduction of new legislation, it must, as a matter of course, be supported by a policy document. So the minister with the responsibility, he gets the policy document drafted. He satisfies himself that this is a policy that he can take to cabinet. The cabinet considers it and approves or disapproves of it. In this case, it was approved. And it was approved on March the 4th, 2013. No, it went to cabinet on that date. The matter for the consideration under the heading Proposed Policy for the Amendment of the Bail Act, Chapter 460. The matter for the consideration of cabinet is the amendment to the Bail Act in accordance with the proposed provisions set out in the policy at appendix attached to this note. Paragraph 9, Madam Speaker. Madam Speaker, I'm being disturbed by the member for Siparia.
Members, I expect this is the last time I'll rise on that point before the suspension. Please continue.
Paragraph 9, Madam Speaker, says, Cabinet is also advised that with reliance placed on land as the main means of security for bail, there has been blossoming a lucrative black market for professional bailers. There are persons who hold deeds to parcels of land either on their own or through agents, actively trawl the courts daily. For a fee, these bailers offer to stand as surety for persons who have been granted bail. This practice is not only improper in its own right, but has significantly contributed to the spin of illegal practice where false deeds to parcels of land, whether that land exists or not, are being created, bearing all the required features of a legitimate deed. These false deeds are then utilized for the purpose of securing bail. This is in the policy document approved by the member for Siparia as Prime Minister. Paragraph 10 says, even further, where bail is accessed by the offender and he fails to surrender to custody, the process through which the court may move to exercise forfeiture is administratively tedious and amounts to an inefficient use of court's time. Paragraph 11 says, accordingly, the amendments proposed in the appendix are expected not only to eradicate illegal conduct associated with the use of deeds to secure bail, but are also expected to permit more persons to access bail. With more persons being able to access bail, the strain on the remand system would be reduced. Did you hear this, Madam Speaker? No need to rehearse it or to repeat it. Those are words found in a document which a policy document which was appended to a note that was approved. The Ministry of Justice, which cost this country for the short time it spent there, and all the infamous reputation that it acquired for Trinidad and Tobago, $2 billion. The Ministry of Justice, during its time, they drafted this policy. And, Madam Speaker, in this document, I quote, "The law with respect to bail has grown and developed in many foreign jurisdictions with respect to financial conditions. In order to ascertain best practice, the Ministry of Justice examined the bail systems operating in several jurisdictions, including the United Kingdom and Northern Ireland, Scotland, Jamaica, St. Lucia, Guyana, Australia, and the US. This jurisdictional examination and the shortfalls of the bail system highlighted above have revealed quite evidently the need for reform and amendment to the system of bail with respect to financial conditions in order to eliminate the negative effects. To this end, the Ministry of Justice, which was set up by the member, proposes by way of this policy amendments to the Act which are outlined herein. Among the varying conditions," I'm still reading. Yes, I'm still reading.
Members, we shall take the suspension now. We shall return here at 5:05.